It's my lordship. Lordship, I pray that allow me to move one urgent unlisted motion.
What is the urgency?
The urgency is that, lordship, the time frame given 5 days expires on Monday.
What?
Expires on Monday.
Time?
Frame. 5 days was given to me to file written statement. If my lord will recollect that constable case where my lordship took up from Gauhati, the respondent government placed before this honorable court for that they will reinstate the petitioner, and my lord has directed for reinstatement within 15 days. For constable. Now, that direction was for reinstatement. However, instead of it, day before yesterday, they have served another inquiry notice, and 5 days was given to me to submit written statement. That was not sufficient time, lordship, and
Who is appearing for the other side? Miss Livika.
Livika was appearing, but she is not feeling well. So,
Your Lordship, I'll appeal this matter, as she's unwell, Your Lordship.
As per the rules 9(2), you have to give minimum 7 days, if I'm not wrong.
yes,
I think, okay, we'll pass that order today. You give that 2 more days, matter small issue. Okay,
lordship.
unlisted.
Yes.
But you should be prepared with that. Prepared with your written statement by now.
Lordship,
Why should we go into such details? Why, if you can file a written with petition and not
lordship,
file the written statement, doesn't make any sense.
that was that I only got it day before yesterday, and I got the news only yesterday, and they only yesterday. It was on 27th,
Okay, we'll see.
lordship.
Yes.
But your Lordship, yesterday I passed over a matter.
For
And
today.
Case has come up in the supplementary list,
Hmm,
item 17.
yes.
Look, may I pray for your indulgence to update the matter and hear you?
Okay, no, it will be otherwise.
There are some.
After it will be item number 11, 12 at best.
Yesterday also, it was.
Mr. Counsel, if you want, I can finish up all these matters by 12. All these matters will be over. It doesn't take much time. I do 80 matters a day.
From the supplementary cost list for motion, item number 15.
Yes. What is this?
The petitioner is praying for revision of his pay in terms of the Negligence services, revision of pay rules 2010 and 2017.
You're asking for?
For revision of his pay, scale of pay, the revision of pay in 2010 rules as well as the 2017 rules has not been affected.
To you.
Yes,
Who are you?
Lordship, I am a bail
In?
in the office under the
Educa-
higher education. I'm presently serving at the
So you are not given the benefits of the 2017.
2010. There was the 2010 rules and then 2017 came. Both have not been affected in my case.
Lordship, in this, please notice may be issued.
Very well. I'll issue notice, but I have heard and I issue notice making it returnable on 15th of September 2025. Mr. So-and-so, K. Angami accepts notice on behalf of the respondent numbers 1 to 5. Gusto. Extra copies be served upon him during the course of the day. The case of the petitioner herein is that the petitioner was appointed as a driver under the establishment of the principal Dimapur College, Dimapur, by an order dated 11/1/2000. At the time of the appointment of the petitioner, he was given a scale of pay of rupees 900-25-1025-30-1445-35-1760 per month. Pusto. It is for the case of the petitioner that the petitioner was appointed to a vacant, to a substantive vacant post. Subsequently, by another order dated 26/4/2022, the petitioner was appointed temporarily in the scale of pay of rupees 2750-70-3800-75-4,400 per month under the establishment of the Dimapur College, Dimapur, as the driver. Pusto. On account of an unfortunate incident by which the petitioner had suffered a stroke, the petitioner requested the respondent authorities to appoint him in a lower post of peon. So considering the petitioner's request, the petitioner was appointed to the post of peon in the scale of pay of rupees 2550-55-2660-60-3200 per month. Pusto. The appointment of the petitioner, as claimed by the petitioner, was against a substantive vacancy. The case of the petitioner herein, the grievance of the petitioner herein, that although the Nagaland, what is that rule?
Nagaland services,
The Nagaland Services bracket revision of pay bracket rules 2010 was given effect from
one,
1/1/4/2006,
1/8/2008.
1/8/2008. And the Nagaland Services bracket revision of pay bracket close rules 2017 was given effect from, what is the date? 1/4/2016,
Okay, well, just
with effect from so and so.
what? 1st June 2017.
1st of June 2017. But the petitioner have not been granted the benefit of the revision of pay in spite of the petitioner having approached the respondent authorities on various occasions. It is under such circumstances the petitioner has therefore approached this court seeking an appropriate redirection and order. The respondents are directed to bring on record their stand by filing the affidavit on or before 11th of September 2025 as to why the petitioner have not been provided the benefit of the revision of pay in terms with the rules of 2010 as well as the rules of 2017.
Matter what?
For admission, item number 1.
So much. Okay, I have for the petitioner on behalf of my senior, I'm Jeff.
What? What are you challenging?
No, please, my lord. Lordship, on the.
Pension and pensionary benefits.
Yes. On the last occasion, your lordship, the counsel for the accountant general has submitted a list of pensions approved by the accountant general office on 1st and 2nd week of July. However, in that list, there was no letter annexed showing that to where that particular list has been submitted to. And therefore, this court has asked both the counsel for the accountant general office as well as me to get this instruction on the issue. Lordship, I have received the instruction from the respondent number 2 hearing, my lord, if I may be allowed to place this.
Yes, Mr. Albert, why the judge have not been given the benefit of the fact? Yes.
Lordship, here, the accountant general office has prepared the PPO, that is the payment pension order, and it has been sent to the District Treasury Office, Kohima North, a copy of which has also been endorsed to the petitioner, Your Lordship. On the next page, my lord.
And what it is given, not for payment means?
Lordship, since the pension has already been approved now, it is only for regards to the payment which the petitioner has to receive it from the District Treasury Office, Kohima North.
No, I don't understand. When did the petitioner retire? The petitioner is a family pension holder.
Lordship,
The petitioner is the legal guardian of the two minor children.
No, understand. The petitioner expired?
yes,
Yes, Lordship.
yes.
No, petitioner did not expire.
No, petitioner's late husband expired.
So that is what.
Yes.
Petitioner's late husband expired. No, who is the yeah? Of so and so, yes. No, Atase Santam, ex-stenographer.
Yes,
So the petitioner is seeking the family pension of the deceased employee.
correct.
When did the person expire?
2008.
Until now, no pension has been given?
No, Your Lordship, what happened is the petitioner was not regular servant at that point of time. And therefore, his regularization was subject to approval of the PNR, many things, Your Lordship. Now everything has been done. Everything has been done.
Now,
Yes, now only the payment of the pension was left, where the Accountant General Office has already enclosed his name in the list that was prepared in July, Your Lordship. And the same has been sent to the District Treasury Office North for necessary payment.
now the PPO has been done.
Done.
Now with the PPO being done, then the right accrues
Yes.
to get the family pension.
Correct, correct.
Now, when are they going to get the family pension
No-
along with the arrears?
Yes, Your Lordship, it is with effect from the 24/6/2008, and since it has been sent to the Treasury, I think the petitioner should know by now whether the payment he has received it or not.
Lordship, the petitioner is yet to get any instructions, so kindly grant 1 week's time to let the petitioner go to the office and get the instruction. Looking back to it.
No, the payment will be paid to the bank account.
He's yet to receive. The petitioner has not received any PPO book.
PPO book has not been received by you.
It has been received, Your Lordship. His name is clearly reflected at the below this thing, Your Lordship. OP2.
Okay, you do one thing. Let me pass some orders on the basis of this. You go on Monday, take the PPO. From whom? Where's the PPO book?
Lordship, it seems that the PPO book has already been submitted to the petitioner as per the letter of the Home
Directed to
Secretary.
inform the EA for the family pension of the Iman. That has been received from the account and handed over to the eligible family members.
Correct.
It has been given.
Yes.
Lordship, as per my instruction, the petitioner has not received. So,
This was given on 19th of August. When did you talk to this petitioner?
so, kindly.
Okay, you do one thing. You go there. Let me pass an order. Okay, on Monday you go there and inquire with these people. The secretary, whoever it is. To whom should he meet? The petitioner.
Secretary
And
of department.
You see,
Yes.
the secretary is a busy man.
Yes, yes.
Tell me whom should the petitioner meet?
Chief, any officer below the rank of a secretary, starting from under secretary or deputy secretary, that will do.
Mr. Angami,
Yes.
it would be very kind enough on your part to give the name of the person so that she goes and meets. And then the things can be resolved.
Yes.
But there are 10 officers or 20
Yes.
officers, whom should you meet? So you give me, we'll
Yes.
take it up at 11. Just give us the only information whom
Yes.
the petitioner should meet
Your
for
Lordship,
making an inquiry.
in fact, it should be the joint secretary because we don't have additional secretary. The
Okay.
joint secretary.
Joint secretary?
Yes, Home Department.
On Monday.
On Monday.
You go and meet, and then we have it next week only. Before I leave, I think you should get all the details. The grievance of the petitioner herein is that the petitioner was not provided the family pension for which the present writ petition has been filed. It appears that because of certain intervention and certain orders being passed, the services of the petitioner's husband was duly regularized, and thereupon the pension payment order bearing number, where is the number? There is a number there somewhere.
Yes, Your Lordship. PPO number 142 539 714.
Have been issued. And there are certain directions also issued by the Office of the Accountant General for payment of certain amounts. The learned counsel appearing on behalf of the petitioner submits that she has not received the PPO. Full stop. She has neither received the PPO nor have received the dues as directed to the district treasury officer to disburse. Full stop. During the course of the hearing, Mr. N. Angami, appearing on behalf of the state respondents, submitted, have given copies of the communication issued to him, the instructions issued to him, as well as the PPO, as well as the intimation given to the district treasury officer for payment. But it has been given to Joel Santam.
Yes, Your Lordship, this is the son.
Joel Santam is a party.
Yes.
He's a party?
Yes.
Okay. Yeah, where certain directions have been issued to the district treasury officer for payment of the family pension as well as payment of gratuity. Full stop. The said communications, the instruction, a copy of which have also been furnished to the learned counsel for the petitioner, is kept on record and marked with the letter X. So taking into account that the counsel for the petitioner submits that the petitioner have not been provided with the pension payment order as well as any other, as well as have not received the dues, this court directs the petitioners to approach the Joint Secretary to the Government of Nagaland on Monday, on 1st of September 2025. And the Joint Secretary to the Government of Nagaland shall clarify the said aspect. Full stop. List this matter again on 4th of September 2025 for an update.
Deeply obliged.
You give a copy to her. Huh?
Yes, I have given.
Yes.
Obliged.
For admission, item number 2.
Yes, Your Lordship.
Yes, madam.
Here we're challenging the eviction order issued by the Northeast Frontier Railway, my lord.
Eviction?
Yes, my lord.
You've been evicted
Yes, my lord.
from the
And-
Patta land.
Yes, my lord.
Then
However, there's a stay order in operation, my lord. Your Lordship, we have received the affidavits filed by,
notice
the state-
bearing number so and so. This is by the railways.
yes, my lord.
Where the railways?
Mr. Y.P. Gupta is appearing for the union as well as the railways, my lord. They have filed their affidavit, my lord.
What do they say?
And both the state and the railways, they are saying we're illegally occupying railway reserve land, my lord. However, that is not true, my lord. This is a private land.
But
So they are not
you see, whether action was taken under the, because if it is a railway land, the railway has to take an action under the Public Premises Act.
Yes, ma'am.
Have you taken that action?
Yes, ma'am.
Where is that?
No, my lord, I'm appealing for response number 6 and 7
Okay.
for a state response.
Tell me. Where is that? Where is that order of 16.2? Madam, show me which is the order they are referring to.
Should the eviction order is at page 26. Type
26,
copies at
order
page
of
27.
demand. Okay, now this is done under the Public Premises Act,
Yes,
isn't it?
Yes,
Then madam, tell me why should this court exercise any jurisdiction when you have an appellate jurisdiction under 11?
Worship, this is a private land, my lord. We have been in possession of
Understood, that is the
land
case.
since the 1940s.
Madam, that is the case you have to set out in the appellate court, nah? Where you can give evidence. Don't you think that?
Worship, in fact,
I
Lord,
do
no
want-
notice was issued to us prior to this eviction order also, my lord.
No notice was issued.
No show cause notice was issued to us, my lord.
Have you made that allegation?
Yes, my lord.
Where is your allegation?
My paragraph.
Here they say,
Paragraph
I have
12.
issued a notice dated demand to submit show cause before so and so regarding unauthorized 14/11/2022. They say,
We have never
and
received
you
that,
did
my
not
lord.
appear on 6/11.
Lordship, if your lordship can kindly turn to my paragraph 12, page 10, my lord, I have clearly.
What do they
stated-
say about that notice?
Clearly stated that I was never served upon the notice dated 14/11/22, my lord.
Should be illegal to illegal also who were illegal occupying. Where is that notice? Who is paying for the railways?
Your lordship, my senior is out of station. And
Shall we let us interfere with this order? But madam, if the notice has not been issued, then also you can take that issue there. Now, Mr. Counsel for the respondent state, tell me one thing. The petitioner claims that the land is a patta land.
Yes,
so,
What do you say about that patta?
my lord, in that regard, verification, sport verification was conducted. And in the verification, it says that the land which she is claiming, the land which the petitioner is claiming is coming under the doc number 131. And here it is talking about the doc number 10, my lord. Your lordship, may kindly see the verification report.
Patta give.
Yes, page number 12. Your lordship, may kindly see my affidavit in opposition, my lord. Page number 12.
Patta has been given for which tags? Tag number 19, 25, 251, 254, 256.
Lordship, in fact, we were also not aware of this DAC number 10, only after the filing of the state affidavit, my lord. We were produced with this.
But let us see their notice where they have passed that order, no? Where is
Page
that-
number 27.
No, where is the impugn order? There is a mention of it.
Page number 27 is the DAC copy, my lord.
The problem which arises, madam, is that this court cannot look into those things. Now, I'm exercising 2 to 6. Very difficult. Spot verification, which I have to request you to kindly conduct survey of patta number so and so measuring standing in the name of Angami and ascertain whether the land falls under the so and so enclosed area. This is by the revenue settlement officer. For yeah. In pursuance to the Honorable High Court's order dated in connection with Iman, a joint eviction is hereby fixed. So and so, so and so, so and so, so and so. All concerned for says, for on pursuant to the Iman, the joint has been conducted Iman. For the joint report of the surveyor, the following officials were present. In pursuance to the so and so, the Iman. On verifying the position, it is certain that the land falls under dark number 10 of block number and measure an area of 50,000 of Iman or Iman. Shita record that is recorded in here. Moreover, it is to mention that so and so constructed on dark number 10. Okay. But this is the record 10 to 54. Your land is outside, madam.
Yes, my lord.
Then what is there? Nothing.
Doesn't fall within
Madam,
the
I give you
station
two
area, my lord.
options. I give you two options to delay. One, you take a dismissal today. Secondly, you go there. Either of it.
My lord, my prayer is, my lord, the petitioner has filed an RTI application on the 21/8/2025.
Madam,
seeking for
kindly understand.
information
Madam,
about-
kindly understand. There is an effective remedy available.
Motion.
Okay? Under section 10 of the Public Premises Act. You are normally to file an appeal within 9 days. You have not filed an appeal, you have approached this court. Okay. I can condone that aspect and asking you, giving you 9 days to file an appeal. These aspects as to whether dark number 10, whether the land is in dark number 10 or not, these are questions which can be very well looked into by the appellate authority as the appellate authority is exercising a power under on facts.
This is also one of the queries I have put in the petitioner has put in the RTI application, my lord. So we're just awaiting for that report so that we can file an.
Madam,
And
RTI
short
application
reply,
cannot
madam.
help you because of the fact that your land which has been mentioned, your patta
Yes, my lord.
and dark number 10 is different. And they say that you are in occupation. These are questions of facts. I can't help you. Take your better advice from your
Lordship,
colleague.
if your lordship will be gracious enough to list this matter on Monday, then my lord, if my senior can.
Who
be present.
is a great senior?
Lord, my senior, Mr. Ijumomi, he is out of station. He is reaching only today, my lord. So
Okay, good.
if
I
can
won't.
some-
I would not dismiss in your hand. In the hands of your senior, I'll dismiss.
Senior can.
But then I don't give the liberty under 10. Remember that. That I'm leaving it. Because you see, it is not be proper on my part, but then also let me tell you.
Yes, my lord.
When you file an appeal, it's an appeal. Appeal is a creation of a statute.
Mhm.
So that district judge, the appeal lies before the district court. The district judge has to look into facts, call for the records, go everywhere. In Gauhati, if these type of matters come, the first day matter finish. Because I can't look into this. Second, if it is a question of fact, my question of interference becomes very limited. I can't look because I am not sitting. I'm only looking into the decision-making process. And from the materials, you say that you are on your private land, but they say that they are not in your private land. Secondly, you have not challenged that order also. Where is the challenge to the eviction order? These are eviction orders you are challenging. So then you are challenging the
Lordship, my
notice,
prayer-
notice and order. And the counsel for the respondent,
Challenge the order.
why don't you do one thing? Taking into account now,
Yes.
their basic grievance is that they were not issued a notice. Because the notice is only given for a period of 7 days, if you see. And then take into account these materials which have been given by the state, wherein it says that the land falls now here, it is a railway land. They are to only say that as to whether they are going to, as to whether that land is there, they have to prove it. They cannot prove it because of what the state has come up on the basis of the findings. And then go ahead under Section 5 and evict them. You see, pendency of this matter is affecting the rights of the railways. It's a sad thing that the Railway Council chooses not to appear.
My lord, here the notice was issued by the railway.
Understood.
So
Now, you see,
yes,
if good sense prevails on the Railway Council, is that okay? Now, in view of this, they are going to issue a fresh notice. They already have the verification done. Now they have to only issue a notice that look here, this is it. And within 7 days, and then 7 days you pass an order and finished. Within 15 days, the matter is over. But if I set aside this, they have a right of appeal by which it will get delayed. YP Gupta's junior, you are there. Show him the video, what I said. And we'll take it up on Monday and tell him that he should say that, make that submission before me. List the matter having been heard at length, the matter be listed again on 1st of September for final disposal.
Should the interim can continue to.
Interim, nothing is going to happen. Interim order pastoral shall continue till the next.
much also.
But that is the best way.
Yes.
Now, with that evidence, you have got through the court.
For admission, item numbers 3 and 4.
This, Your Lordship. Your Lordship, we've received affidavit in opposition of the respondent number 1 and 5.
What?
1 to 5. Affidavit in opposition
You have filed?
we've received from the respondent. 1
When?
and 5.
When did they file? When we had summers. Now we are in the autumn. That
Your Lordship,
season have changed, but you have not filed your reply.
kindly allow some time to file the affidavit in reply.
The counsel appearing on behalf of the petitioner submits that a final opportunity be granted to the petitioner to file the affidavit in reply to the affidavit in opposition filed by the respondents numbers 1 to 5. Taking into account the above, now this court duly takes note of that the affidavit in opposition was filed on 23/6/2025. Full stop. Taking into account the above, list this matter again on 18th of September 2025. The affidavit in a final opportunity is given to file the affidavit in reply by 15th of September 2025.
For admission, item number 5.
Yes,
My lord, I have filed my petition on 26th.
you want to file reply? Affidavit in opposition? Any of you? You will file?
Your Lordship, we have received the amended petition this morning, so can you grant us a week's time to go through?
Yes, Your Lordship. I've received the.
You want to file an affidavit in
Your
opposition?
Lordship, I will not be wrong.
Okay, now let us see what is the case. Okay. If they don't want to file, it is the action of the deputy commissioner. So your case is the question of jurisdiction as to whether the secretary of village district development board can be selected and appointed by the deputy commissioner.
Yes, my lord.
That's all. Madam will show. Others, they don't need to say anything. They can take the seat.
Your Lordship, the selection and election of VDB secretary and its members is usually done by the.
I am very good, number 5. After filing the affidavit in the possession, after detecting some defect to the petition, the petitioner sought for amendment of the petition, which was allowed.
No, Mr. Counsel, kindly
I-
appreciate. We are not on anything on facts. The only question is the question of jurisdiction. As to whether the deputy commissioner has the power to appoint the secretary of VDB, or it is the VDB who can decide, or village council decide. That's the question. It's a question of the law.
Now, I received the consideration this morning. Only this morning.
You are too experienced a counsel for that to look into this. We are on a question of law.
And secondly, Lordship, the petitioner is challenging my appointment to the secretary of village development board. Lordship, I raised an objection because the selection has to be done as per the rules. There is a role, Lordship, village development model rules. And as per the rules, it is the village council to select the village village secretary, and the name has to be forwarded to the commission. There's a rule.
So,
So accordingly, I was selected by the village council. However, village council is not a party here. Village council is not a party here in this commission, who is necessary part of to answer the queries. So all those things are there, Lordship.
This one is not regarding the village council. This is regarding the village
Correct,
development board.
Lordship.
So my lord friend is saying that this is with regard to the village council, but this one is not with regard to the village council. This is with regard to the VDB management committee member, my lord. And appointment of the VDB member secretary, my lord.
21/6/2024. Now, the question is who can appoint the secretary? That's all.
Deputy commissioner has the power to complete approval. Do the reference made by the village council. Because selection was made by the village council as per the rules.
So you say that the village council has selected you
Lordship,
and sent it for approval to the deputy commissioner.
Lordship, as per
And the deputy commissioner thereupon has appointed you.
Lordship,
Let us take your facts to be absolutely correct.
Lordship.
Now, the question is, was it done? Is a question which because the problem arises because the state is not going to file any affidavit.
They filed.
No, they don't want to file an affidavit to the amended petition. So therefore, what the state have stated is what we are to look into it. Neither what you say or he says. Or he says, it's the state who is the main. So, Madam Amy will make her submission.
And Lordship, I have one request, Lordship. Whether.
You made the mistake of sending a junior first by sitting on the back. You should have said immediately then.
Lordship, my name has been forwarded by the village council after selection by the village council.
Understood.
Therefore-
Therefore, Mr. Counsel, we accept it. What you are saying is to be the gospel truth. So we take it that your name was sent by the village council, and then that the deputy commissioner has to appoint. So therefore, as per you, the manner of selection and appointment is that the village council will select an appointment and what would be name would be forwarded and the deputy commissioner will appoint. That's your contention. We take it as it is. Now, whether the law prescribes that manner is the question. Let us see, madam. Where is the law for appointment of AR? Please.
I agree on behalf of the law department. Lordship, None of which never present also there. So I was informed to prepare on behalf of him. And worship, I not.
Who are you?
Or responsible for. On behalf, preparing on behalf.
So,
Worship, I am not.
so none appears for the respondent number 4. Matter ends.
You can take up discipline on Monday, Lordship.
Monday, I've got lots of matters,
On Tuesday.
many matters.
On Tuesday, no. Tuesday.
Mr. So-and-so, the learned counsel appearing on behalf of the respondent number?
Number 5.
Respondent number 5 submits that he has received the amended writ petition and would obtain instructions as to whether any reply is required to be filed in the present case. Full stop. This court have duly taken note of that the issue involved in the instant proceedings is a question of law to that effect as to whether the Deputy Commissioner can select and appoint the Secretary of the Village Development Board, or whether upon selecting, or whether the village Secretary of the Village Development Board is to be selected and appointed by the Village Council. Full stop. That being a question of law, comma, and the matter having been heard, lists this matter on 2nd of September for final disposal. In the meantime, the petitioner, the respondents, will be at liberty to bring on record their stand by filing their affidavits by 1st of September 2025.
For admission, item number 6.
What is this? Filing affidavit, no affidavit filed?
Lordship, I request a short time to file my affidavit in opposition.
This is a matter of 2024. It seems that you don't want to file it.
No, Lordship, there are
Let
so
us-
many clarifications required.
Let us go on the
Yes.
question of doctrine of non-traverse. You have not filed the affidavit. And you have taken so many opportunities,
Yes, Your
isn't
Lordship.
it? I think we should allow it.
I on behalf of the petition,
Huh?
I on behalf of the petitioner.
Petitioner is absent.
My dormitory is not very well so that we forgot I told the presentation.
Set aside the appointment of 2000 to the private respondent number 1. Yes, Mr. Nungle, what is your case?
One of the, I'm appearing on behalf of my dormitory.
Your friend is also not there.
Yes, she is not well. I'm not here, in this case, my lord. I on behalf of my.
I also have the habit of appointment, allowing writ petition without the petitioner also. Don't worry. Recently, I passed it over, just before coming. The council says that my senior counsel wants to argue. I said, okay. And the senior counsel is not there. No problem, let us hear the respondent. I heard the respondent, I found that the petitioner has a good case, so I passed the order, but I recorded. The counsel did not argue because senior counsel was not there. Then I allowed the writ petition. I'll do that.
Your Lordship, 2 weeks may be given from.
Wait a minute, it's a long time back, no?
Yes, there were lots of clarifications required, Your Lordship. I just received it on Monday.
Question of clarification cannot be there. No? The appointment order is of 5th of December 2023. We do one thing, we pass an interim order not to release your salary.
Your
Matter
Lordship,
over.
the appointment was done as per the selection committee.
So if you are not filing it, but if you are delaying it, you have received, how many times you have taken adjournment? Tell me. 1, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 adjournments.
Your Lordship, the last chance may be given.
And in fact, Mr. Nugle, you must be knowing also. 4 times I see you have also appeared.
No, my lord, that is the training of fully matter.
Yes, a hard.
My name is-
Kindly say 28/11/2024. Hard, Mr. Nugle, the learned counsel appearing for the petition.
Different.
Then you see, and the matter was moved by you.
My brother. My
Oh, you have a brother?
Yes.
Okay, I see, I see. Oh, your brother is there. Okay. So what do you want? Do you want to insist that there is a delay or not?
So, as per the instructions of my brother, I'm insisting, but
Ah, yes. The counsel appearing on behalf of the petitioner submits that the instant writ petition was filed on 11th of September 2024 and notice was duly issued on 17/9/2024. The respondents thereupon have duly appeared, but 10 adjournments have been taken for filing the affidavit in opposition. The learned counsel appearing on behalf of the petitioner further submits that by delaying the respondents have adopted the stand of delaying the writ petition, disposal of the writ petition. Mr. So-and-so, appearing on behalf of the
State respondents.
state respondent, submits that a final opportunity may be given to the state respondents to bring on record their stand by filing the affidavit. You? So-and-so, appearing on behalf of the private respondents, also submits that a final opportunity being given. Footstop, taking into account this court grants a final opportunity to the respondents to file their affidavits. List this matter on 18th of September, the affidavits be filed, affidavit in oppositions be filed by 15th of September 2025 without fail. It is observed that if no affidavit is filed on the next day, this court shall proceed with the disposal of the writ petition on the basis of the materials already available on record and also further applying the doctrine of non-traverse.
For admission, item number 7.
Yes, yeah, affidavit is filed by the state.
Lordship, I'm for risk number 3.
Yeah.
I'm here to file my affidavit.
Don't
I'm
file.
waiting some documents and instructions from the risk number 3. So maybe given it this a week's time or 2 weeks time to file my affidavit, Lordship.
Non-consideration of appointment. Let us see whether it is a case or not. Yes, Mr. Mohajab.
yes,
If he has a case, we see the affidavit. They don't have a case, we stop your appointment. We pass interim orders for not filing the affidavit. Okay.
what's my prayer is for appointment on the basis of land ownership, Lordship.
Land
Now the
ownership.
state, they have already filed the affidavit, and apparently, Lordship, 7 appointments were made on land ownership. So the provision in this section, clause
3C. You don't have a case.
bars me from appointment, Lordship.
From your family, somebody has been appointed.
Yes, Lord. Apparently, Lord.
So there is nothing limit. So why do you have to file your affidavit? Matter ends.
Therefore, my respect to petitioners, if the post have my respondent number 3 can be deferred because it is appointed without any selection process. And if advertisement can be issued where a petitioner can also participate, Lordship.
No, understood, but respondent number 3 was appointed by, how?
Without any selection process, Lordship.
No selection.
Lordship.
Where's the affidavit? That day I passed an order.
So it has violated the constitutional mandate, Lordship.
Oh, yes. You applied on the basis of land ownership.
Lordship.
But you say that in view of the stand being taken by them, you may not be entitled to.
Lordship.
But taking into account, because the land ownership aspect is an exception to the mandate of Article 14 and 16.
Lordship.
And therefore, if otherwise they are to therefore have it, and they must have done it the appointment on the basis of an approval given by the government.
Lordship.
That's all.
Lordship.
Day before yesterday, I passed a judgment. There was one lady advocate, her name was Annie, I forgot, yes. She was your junior? No. Same order, I passed. So we finish it off then.
Lordship, if Lordship may be gracious enough to give an opportunity,
You have been given a lot of opportunity. This is a matter of 2024.
Lordship,
We stop your salary then. Because if it is absolutely illegal, we cannot allow this salary. Don't you work? How much you feel like you keep on working? Where's the affidavit filed by the state?
Lordship, the next week, Lordship. If you have next week, Lordship.
Huh?
Next week, Lordship.
Next week, there are too many matters. As per the list 7, as per the list 7, invalid into the complaint under the bench. Madam, just tell me one thing. How the respondent number 3 was given the preference? Where is it mentioned in your affidavit? Huh? There. You file a short affidavit next week as to or produce the records of the selection. And if it is not there, we will construe that there is no selection. You see the judgment I delivered the day before yesterday in one matter. Okay. The case of the petitioner herein is that the petitioner ought to be considered. The case of the petitioner herein is that the petitioner have not been considered for appointment in respect to the grade 4 staff in the establishment of the chief medical officer Waka in terms with the notification dated 16/8/2008. 18. 16/8/2018. Full stop. The record reveals that an affidavit in opposition has been filed by the respondent state, wherein it has been duly mentioned that there are already 7 persons who have been appointed on the basis of land ownership. And as such, the question of the petitioner being considered on the basis of the notification dated 16/8/2018 does not arise in view of clause 3 bracket small c of the said notification. Mr. Muazumi, the learned counsel appearing on behalf of the petitioner, submitted that if that be so, the petitioner would not be insisting on the basis for appointment, for consideration of appointment on the basis of land ownership. However, the petitioner submits that if the land ownership basis, which is an exception to the mandate of Article 14, 15, and 16 of the Constitution, cannot be applicable, it is the bounden duty of the respondent authorities to comply with the mandate of the said articles, else the actions would be unfair, unreasonable, as well as arbitrary. Full stop. This court further, taking into account the said submission, this court inquired with Ms. So-and-so, the learned counsel appearing on behalf of the respondents, as to whether there was, how many candidates applied to the post of, to the vacant post which had arisen in the establishment of the chief medical officer Waka. And was there any selection proceedings in that regard? And what is the basis on which the respondent number 3 have been appointed, have been granted, have been given the appointment? The learned counsel submits that she would obtain instructions in that regard. List this matter again on 4th of September 2025, on which date the respondents state shall provide the instructions without fail. In the meantime, liberty is given, final liberty is given to file affidavit. Liberty is given to the respondent, private respondent, to file the affidavit if so advised.
For admission, item number 8.
The pleadings are completed.
Huh?
Pleadings are complete, Lordship.
Pleadings complete.
Lordship.
Shalom. What is the who claims to be a teacher serving as substitute in Maniman under
Lordship,
the establishment of your petitioner joined and petitioner continue to render
To the extent, Your Lordship, the petitioner is praying only for
up to some time for after submitting for the council for the family submits that the prayer meeting is in the post of graduate teacher in which she is rendering and substitute not present no prayers are made to the or any prayer from this court. His prayer and present is to regard to regular scale of pay at par with other employees. So you want the minimum scale of pay?
Lordship. Since I'm I'm performing duty, Lordship. Even though I'm working as a substitute, I've been performing my duty.
How many years? You have been working?
Lordship, since 2012.
Have you seen the recent judgment, Dharam Singh?
Lordship, yes,
I gave it to some of the councils.
yes,
Try to develop your argument on that.
Lordship.
Because there it says that if you are using their services for long,
Yes, Lord.
on the basis of financial constraints or not, you cannot take this. Because the stand which was all along being taken by the state in many matters and orders being passed by this court, that not to run. That a person who has been working for last 12 years or 13 years, and he is not being given the scale of pay is on the basis of the financial constraints of the state. But can the state have financial constraint for a period of more than 13 years and allow you to work on an ad hoc basis? So that is a very important judgment. I think you develop, and I think if necessary, you file an additional affidavit.
Lordship.
Because there is one very important aspect where the court says, taking out from Umadevi, say,
Yes.
there is one thing that regularization cannot be granted is another thing.
Yes, Lord.
But the fact that there is no sanctioning of a post and thereby continuing to employ a person as an ad hoc, taking his services, amounts is subject to judicial scrutiny.
Exactly.
You take the judgment, look into it.
Lord.
And I have given one copy to Mr. Muajumi.
I'll get it from
I have given a copy to Mr. another one. Huh?
I have Lordship.
Ah.
can.
You develop your, if necessary, you file an additional affidavit bringing that.
Lord.
Then it becomes more easier for this court to do it.
Yes, Lord.
Okay? Because that's a very important judgment. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the pleadings are complete. However, taking into account the judgment, the recent judgment of the Supreme Court in the case of Dharam Singh versus so-and-so versus State of UP, reported in, you asked this, my stenographers, reported in 2025 SCC Online, page something. He would like to file some additional pleadings, if so advised.
Lord.
So accordingly, list this matter when.
Lordship, after a week or two, Lordship.
Okay, list this matter again on 8th of September
Lordship.
or more than that, 15th.
Since she's in Nanapoto, I think
Okay.
2 weeks. Lord.
Let us have it on 22nd.
Lordship.
Okay.
Lordship.
Now tell me, this is Kohima, na? 22nd of September. In the meantime, the petitioner will be at liberty to file additional pleadings if so.
How do you like?
For admission, item number 9.
This is Lordship. Lordship, this is also a land ownership appointment case where the department has sought verification of the DC. So-
Where the affidavit is, I see there's some affidavit file. Affidavit filed by respondent number 5. The state has not filed the affidavit.
No, Your Lordship, we are waiting on the verification report from the DC of 1.
You have appointed somebody by land ownership basis.
Not yet, Lordship. Not yet, Lordship. The
So
approval has
you
been
want
sent.
yourself to be appointed, there's an appointment approving for appointment on, again. Now, respond number 5 has been appointed against whom?
He-
Who is the
Not yet
counsel for the
appointed, Your
respond number
Lordship.
5? What is his name?
Your Lordship, appointment order has not yet been issued, just the approval.
There's a stay,
Yes, of the approval.
there's a stay.
Yes, Your Lordship.
So you have not filed your affidavit.
Not yet, Your Lordship.
And when are you going to file?
We are waiting for the verification report from the PCA one. As to verify the claims of the petitioners.
Okay, Mr. So-and-so appearing on behalf of the respondent state submits that the Deputy Commissioner Mon is presently inquiring as to whether the petitioner herein has a legitimate claim on land ownership or for appointment on land ownership basis. And it is on account of non-submission of the said report, the respondents are not in a position to take a decision as well as file an substantive affidavit in that regard. Taking into account the above, list this matter again on 25th of September 2025. The affidavit be filed by the 19th of September 2025 by the respondent state. First, interim order is there, na?
Lordship.
Interim order passed earlier shall continue till the next date.
Lordship. For admission, item number 10.
Yes.
Lordship, this matter was incarnated from a long litigation. So now the petitioner is praying for the minimum, which is but Your Lordship, I'm yet to receive an instruction. So some more time will be granted.
You have
Okay,
no
so-
objection, I suppose. Mr. Imti Song, the learned counsel, is additional AG, submits that the instructions are awaited in the matter from the respondents, and as such, the affidavit has not been filed, could not be filed. The counsel for the petitioner submits that he has no objection. First of list this matter again on 7th of October 2025. In the meantime, the respondents are directed to file, no, we'll have it on 9th of October 2025. The respondents are directed to file the affidavit on or before 6th of October 2025.
From the supplementary cost list for admission, item number 16.
Yes, no case.
Lordship, if I may allow to. Okay, this is for a lay person.
No. This has come only in existence to my after my order. Can't help you.
Lordship, here, the fact is that the grandfather
Your
equally divided the.
Your auntie have already, your father's brother's wife have already got the appointment.
Lordship, both of them are legally the landowner, Lordship.
Legally,
grandfather
no,
is
the
already
no, the
divided
thing, no,
shares.
the thing is like this. The land was given by your grandfather.
Yes, Lordship.
When the land has been given by your grandfather, then all these divisions were not there.
But Lordship, before the death of my.
So
mother,
did you
both
object?
divided-
Did your father object when your grandfather gave that land? The fact that your grandfather gave the land is not in dispute. So when your father did not say anything, when your grandfather given the land, then
Lordship, seems the land was already divided into equal shares, so both of them are legally entitled.
So tomorrow you may very well say that your son, just for example, you have there's one person concerned, he has 4 persons, the sons and daughters. One of that very person, that very person, he donates the land. Then are you going to say that each person of the family will have a right? Because they don't live together. This will be in violation to 3C. No case. Who is appearing for the government? I told Miss Mary that
Yes,
she
sir.
need not appear.
Yes, sir.
Any of her counsels can very well appear and just say
Yes, sir.
that I am appearing for her.
Very much your best man, Lordship.
Yeah, that's the only submission required. Chalo, I dictate. I gave you that day wholly. Until heard Miss So-and-so, the learned counsel, appearing on behalf of the petitioner, and Miss So-and-so, who appears on behalf of the respondent. This court on 27/8/2025 heard this matter at length, on which date Miss S. Mary, the learned government advocate, had made elaborate submissions. First, this court, only for the purpose of providing an opportunity to the respondent petitioner to obtain instructions, had fixed the matter today for final disposal. Next, the facts of the instant case, as would appear from the pleadings, is that the petitioner, who is the daughter of one Netahu Venu, belonging to the descendants of Venu clan, V-E-N-U-A clan, of Peg district, claims to have given land to the government for establishment of the Deputy Commissioner's office and its peripheral areas of the other government establishments. Full stop. It is the case of the petitioner that the government had taken over the said land from the aforesaid landowner with an oral commitment and condition that the appointment of the grade 4 staff shall be given to that landowner. Full stop. The petitioner lays emphasis on her claim on the basis of the certificate dated 31/8/2021 and certificates dated 31/8/2021 and 13/5/2022 issued by the Village Council, Chairman, Peg Village, Nagaland. Full stop. The petitioner, on coming to learn that a post of peon was lying vacant in the office of the Deputy Commissioner, Peg, on the retirement of one Mukhai, M-U-K-H-A-Y-I, applied for appointment to the said post on land ownership basis. Full stop. In addition to that, the petitioner also submitted a recommendation letters dated 25/7/2019 and 28/9/2016. However, to the shock and surprise of the petitioner, the respondent authorities have regularized the respondent number 3 against the retirement vacancy. And it is under such circumstances, the petitioner had submitted the representation before the respondent authorities, which being not considered, the present petition has been filed. The record reveals that by an order dated (15/1/2024), this court issued notice making it returnable by 4 weeks. First, the respondent state had filed an affidavit in opposition on 22/2024, wherein it was categorically mentioned that there was no official record to prove that there was an oral commitment and conditions for appointment to the post of grade 4 shall be given to the landowners by the government while establishing the Deputy Commissioner's Office fake. It was also mentioned that the certificates so given by the village councils have no relevance, taking into account that the village councils were formed after the Nagaland Village and Area Councils Act 1978. And as such, the village council could not have had no authority to give conditions for appointment as mentioned in the certificates enclosed to the petition. It was further stated that presently there are 5 regular MTS from Fek village alone employed at Deputy Commissioner Fek, out of which 3 are from Venu clan of the Fek village, namely number 1, Sosapalu, Chosapalu Venu, number 2, Vizopa Venu, number 3, Hupane Hupaniei Venu. It was further mentioned that Srimati Sosapalu Venu MTS is the aunt of the petitioner, and as such the question of appointment of grade 4 staff not given to landowners as claimed by the petitioner is untrue and baseless. First of all, the respondents, along with the affidavit in opposition, have enclosed the application so filed by The respondents further to the affidavit in opposition also enclosed the addendum to the notification, addendum dated 18/10/2022, wherein it was stated that the appointment on land ownership will not be for perpetuity, and the recommendation of the appointment will be a one-time consideration only. It was further mentioned that the appointment to the post of grade 4 is not a political appointment. Rather, it was appointed in accordance with the laid down guidelines and rules of the government. It was further stated that the private respondent have been regularized according to the guidelines laid down by the government, that all vacancies arising in the district shall be filled up on 67.30 is to the double dot 33 basis between the in-service and fresh candidates. Full stop. Pursuant to the said affidavit in opposition being filed, the petitioner had filed an affidavit in reply wherein it was mentioned that the land which was taken for establishment of the Deputy Commissioner's office, PEC, belonged to three persons, namely one, Nepachi Venu, number two, Vezoze Venu, and number three, Netau Venu, bracket, father of the petitioner. It was mentioned that it was stated that Srimati Sosapalu Venu and the petitioner are not related in any manner whatsoever. It was also stated that Srimati Sosapalu Venu was neither the landowner nor donor, and the appointment of Srimati Sosapalu Venu was based on political appointment. An affidavit in a rejoinder was filed by the state pursuant to the affidavit in reply filed by the petitioner. Pusto. In the said rejoinder so filed by the state on 19/8/2025, it was the statements made by the petitioner at paragraph number 5 of the affidavit in reply were denied. It was categorically stated that Srimati Sosapalu Venu is the wife of Sri Lhuevezo Venu, who is the elder brother of Sri Nietahu Venu, the petitioner's father. Full stop. It was further mentioned that the appointment of Srimati Sosapalu Venu was on land ownership basis and not a political appointment as stated by the petitioner. Annexure A to the said rejoinder affidavit is the landowner certificate given by the chairman village council PEC, wherein it was stated that the Srimati Sosapalu Venu, wife of Lhuevezo of Fake Village, is the landowner. Full stop. The application filed by Srimati Sasapalu, so Mrs. Sosapalu Venu, was enclosed as Annexure B, wherein it was Annexure B. A perusal of the said Annexure B reveals that the said Mrs. Sosapalu Venu claimed appointment on land ownership basis against the vacant post caused by Mr. Theyekhayi, who retired on 5/1/2001. And there were endorsement made both by the Minister Rural Development as well as the Chairman of the Village Council, recommending that Srimati Sosapalu Venu, Mrs. Sosapalu Venu, be appointed, is a bona fide landowner of the DC office compound. It will further mention in the said rejoinder affidavit that pursuant to the certificate placed by the petitioner dated 4/9/2024, whereby it was certified that Mr. Netanyahu, Neitahu Venu, of fact village was one of the traditional landowners of the area presently occupied by the office of the Deputy Commissioner Fact. A verification report was submitted by the head DB bracket Sardar District Customary Court, wherein it was ascertained that the land on which the Deputy Commissioner's office FEC exists is a joint ownership of 5 descendants as mentioned. They were, number 1, late Soy Venu, father of late Luvezo Luvezo Venu and Neitahu Venu. Number 2, very difficult for me to pronounce. 1 to 5. It was also mentioned in the re-verification report that the descendants of late Soya Venu late Vezo Venu and late Moisa Lohe have already availed MTS bracket grade 4 post under the Deputy Commissioner Office FEC. This court, on the basis of the pleadings, in the backdrop of the above pleadings, this court have also heard the learned counsels appearing on behalf of the parties. It is relevant to take note of that for appointment to government posts, the mandate of Article 14 and 16 of the Constitution have to be duly complied with. However, the government, in tune with the mandate of Article 14 and 16 of the Constitution, can provide exceptions by making reasonable classifications. The reasonable classifications by which the government of the state of Nagaland have taken on the basis of a reasonable classification the government of Nagaland had adopted a criteria for granting appointments on the basis of land ownership, subject to compliance with certain terms and conditions. The notification which holds the field presently is the notification dated 16/8/2018, read with the addendum dated 18/10/2022. One of the conditions stipulated therein one of the conditions stipulated therein is the appointment on land ownership will not be for perpetuity, and the recommendation or appointment will be a one-time consideration only. In the backdrop of the above, if this court duly takes note of the facts involved, as would appear from the pleadings, it appears that the land that out of the 5 landowners who had donated the land, one of them was late Soya Venu, who was the father of late Luvezo Venu and Nitiao Venu. The wife of late Luvezo Venu have already taken the benefit of appointment on land ownership basis. Under such circumstances, in the opinion of this court, taking into account clause 3C of the notification dated 16/8/2018, as well as the addendum dated October 2022, it is the opinion of this court that the petitioner herein cannot be permitted to claim consideration on the basis of land ownership. Under such circumstances, this court does not find any merit. This court also duly takes note of that the state of Nagaland, in order to regularize its employees, have adopted policies, have adopted a policy by an office memorandum dated 17/3/2015, which permits regularization in the ratio of 67:33. The respondent number 3, 3 or 5? 3. The respondent number 3 have been appointed have been regularized against the vacant post by applying the parameters of the office memorandum dated 17/3/2015. Consequently, this court does therefore do not find the instant writ petition to be a fit case for exercising of jurisdiction, for which the writ petition stands dismissed, interim orders, if any, stands vacated.
For admission, item number 17.
Hey, why did Talwar not come? 12 o'clock? I'll hear you after I come back.
Yes,
Well,
yes,
then,
I was just about to mention that.
you wanted the matter to be taken in the first slab, no?
Yes. No, this is first part. Not
First
just
part.
one.
That's pretty
Retirement benefits. Let me come back.
Yes, yes. 5 minutes, okay?
Yes.
Gimana? How are you doing? Yeah. Jadi, kau dia loh. Lordship, the case pertains to prayer for grant of disability pension. Lordship, the petitioner was initially recruited as a constable in the year 1984. Then after serving for about 6.5 years, sometime in the middle of 1919, he started suffering from attack of epilepsy. So, Lordship, he was examined by the unit doctor, and then on the recommendation of the unit doctor, the petitioner was discharged from service on 19/4/1991 on medical ground. Then Lordship, after his discharge, he was examined by the medical board in the year 1993. And the medical board recommended that he was not fit for continuing in the service of the Nagaland Armed Police Service. Lordship, after the petitioner was, after his discharge, represented to the authority for payment of pension on 2 occasions by his representations. But no reply whatsoever was forthcoming on the 2 representations submitted by the petitioner. Lordship, then the petitioner continued to take medical treatment from the hospital in Mokokcho. And then, at the behest of the family friends, the petitioner consulted lawyers and then was advised for several leaves in 2023. And the legal notice was served, and then on receipt of the legal notice, the reply was also furnished to the council. And in the reply, the authority had said that the petitioner was not eligible for invalid pension. So, Lordship, personal representation was made immediately thereafter. And then the representation is yet to be considered. So that is the case of the history, Lordship, leading to the finding of this. Lordship, I have stated in my petition that the reports we have through an RDI application, we have requested for furnishing the reports, service report of the petitioner. But the reply was that they don't have the report in the unit. So the appointment orders and other documents are not with the petitioner.
But Mr. Counsel,
Yes.
tell me, there's an office memorandum dated 22nd of December 2015.
Yes, this was annexed to the reply of the legal notice.
Yes. So this is there.
Yes.
Now, prior to that, You were brought, you
Discharge.
were discharged in the year 1991. What was the rule at that point of time?
Lordship, I think my learned friend will be the best to answer that.
No,
But my,
you.
but my
Not
assumption
learned
is.
friend. Learned
the
friend,
word- Lordship,
learned friend, I'll ask learned friend later on.
Lordship,
Because there are two aspects.
yes.
You have to point out what was the rule at that point of time. Did it permit less than 10 years? Secondly, if now you applied in the year 2023,
Yes, through my the legal notice.
you from 1991 till 2023 means 9 years plus 23 years, 31 years you did not say anything.
Lordship, in the meeting, there were two representations were submitted.
That is of 2023.
No, prior to that. Lordship,
If there is a prior to that also,
Yes,
you have given in 2023 RTI reply. These are of 2023.
yes, Lordship, even the legal notice is 2023, but Lordship will kindly.
No, therefore, the question is, you have given in 2009 one thing.
Yes, earlier to the 2009, there was one.
120 in 2009, then you again slept over the matter for 14
Lordship,
years.
they had, I will satisfy your Lordship on the question of delay. Lordship.
No, it's okay. Pension, I would not insist on much of delay. If you are entitled, you should get it. But you have to show me
Yes, Lord.
the rule which was prevailing then permitted invalid pension less than.
10 years.
Show me that.
Lordship, there were no rule in fact. I have replied in my.
If there is no rule, then there is no invalid pension.
Lordship, that's why initially through my first representation, which is dated date 14, Lordship, I have prayed for pension, general pension portion. Just simple representation, retired.
This Annexure 6.
Yeah,
This
five
is-
copy,
Huh?
5 Lordship, 5.
Annexure 5 has no date.
Yes, it is not dated. Lordship.
So how do I know?
No, Lordship will get, I will refer to the next one,
There is no receipt also.
but this was submitted.
There is no date, whether it is received. Nobody knows anything.
And then there's the second one, Lordship.
Let us go by the second one, which
Yes,
has some
I
date.
have referred. Earlier representation dated nil, Lordship. The enclosed. So, Lordship, 2009 at least I've read it. Now, Lordship, if we go back to the 2015.
But you developed the disease of epilepsy.
Yes, Lord.
It couldn't have been on the basis of, on account of your service.
Yes.
Let us see the CCS rules as regards invalid pension. Because at that point of time, CCS rules was prevailing.
Yes.
CCS
But
rules
this
is 1972.
Yes, Lordship, I've got down my claim by my last representation, personal in 2024. I have prayed for disability pension.
Huh?
Disability pension.
Now from invalid to disability.
Yes, Lord.
Rule 38, Your Lordship.
Rule 30.
38.
The invalid pension.
No, this is the CCS rules.
CCS rule, invalid pension.
This is the CCS pension rules, no?
Lordship.
It's not that.
Lordship, refer to this.
Invalid pension. Invalid pension may be granted if a government servant retired from service on account of any bodily or medical infirmity which permanently incapacitate him for the service. applying for indemnity shall submit a medical certificate of incapacity from the medical authority may this when so. 21,000. So you are asking now disability pension.
Yes, not to be admitted.
So that has to be as per the CCS EOP rules.
That will be in terms of leave,
Where is the CCS EOP rules?
which are working.
This is the minimum that I am asking.
Where is the schedule 1A? Schedule 1A? But if a person is suffering from epilepsy,
That's what.
there has to be, for disability pension, there has to be a requirement of that he suffered during the time when he was in service.
Lordship, the law laid down by the Supreme Court in Traversing versus the Union.
Show me.
This is reported in 2013-7 SSC 316. Lordship,
Huh? This is a different judgment. Hey, I call yesterday's judgment you are giving. Yes, give me the citation, I'll take it up.
it has come.
Got it.
This is 2013. SSC 316. Now, at paragraph 29. Okay, you're looking at 29. Read 332. The conditions under which the disability pension have been given has been summarized in this paragraph law.
NT
29 law. And 29, 1, 2, 3, 4, 5, 6, and 7.
conjoined rating of values produced makes it clear the yearly is to be granted between India and
Should I read law?
Aggravated by the interest of this in so therefore, which is attributable or aggravated by military service. The question whether a disability is attributable or aggravated by the
Lord,
military service
in
is
this case-
determined under the entitlement rules for casualty pensionary awards 1982. Is presumed in sound physical and mental condition upon entering the service if there is no note or record at the time of entrance. In the event of his subsequently being discharged from service on medical grounds, any deterioration in hand is to be presumed to have been during service. Is not on the claimant. The corollary is that the onus of proof that the condition for non-entitlement is with the employer.
So the position of law is that lordship, if at the point of entry, if no notice given that I have some disease or anything was detected, the presumption will be that that I have developed the disease during the course of my employment.
But the question arises is because of as to whether this is on an interpretation of Rule 14.
That is, lordship, 14 is the army rule.
So therefore, there Rule 14 and Rule 9 categorically puts the onus of proof upon the government.
Yes, sir.
But can you apply these principles?
Lordship, in the absence of any other rules. in the
How do you
absence of any
apply
other
the
rules-
military rules?
Lordship, I am in the Netherlands Armed Police. I have served for almost 7 years prior to the onset of the disease. Without any blemish, Lord. There was no complaint from anybody that I have suffered attacks of epilepsy. It was only in middle of 1990 that I was visited by the disease. I've stated that in my petition. And Lordship, in the affidavit filed by the
What do they say in the affidavit? Let us
Lordship,
see.
they say, I'll take your Lordship to the affidavit filed with me.
Lordship, my affidavit is based on the Oregon 2015. There is a clear condition.
No, that is for invalid.
Yes,
Yes, yes, invalid, yes.
He is not on invalid. He is on disability. You see, a disability pension can go ahead irrespective of any other pensions.
yes, Lordship.
So the concept as per
This
this
is
act,
extraordinary.
the rules say, the 1939 rules say, or even the CCS pension rules says that even a person who is having an invalid pension can have a disability pension. The only aspect which appears is as to whether there is an aggravation during the service. Now, in this judgment, the Supreme Court says, applying Rule 9 as well as Rule 14 of the Army, saying that the onus is upon the state to show as to whether this person concerned had a pre-existing disease prior to that. Else it shall be presumed that he had this particular disease during the period when he is in service. Now, there are certain facts which are admitted. A person has been appointed in the year 1984. There appears to be nothing on record to show that you have maintained that at the time of when entering, he had epilepsy. Second, he was discharged in the year 1991 on medical grounds. Third, a medical board was constituted who certified that the petitioner was suffering from epilepsy and was unfit for carrying out any work. And thereupon, he kept quiet, he submitted representation, it's a different aspect. But in the year 2023-24, he had met Mr. So-and-so, which had resulted now in getting something.
And that is a litigation.
Yes. Now, be that as it may, a pension is not a bounty of the state. Therefore, the question out here is whether this aggravation or this developing of the disease, unless you maintain in your records that he had a pre-existing disease, can this court import what has been held by the Supreme Court in connection with the military rules, the rules applying to the armed forces in the present proceedings? That's the long and short,
Yes.
isn't it?
To answer your question, Lordship, they have in the affidavit filed with the respondent.
Yes.
May I just take your Lordship to page 4.
Page 4.
It relates to para 8.
The answer back to say and submit that the
Lordship,
invalid
at the bottom.
pension are two distinct. The invalid pension are granted to employees who are released from service.
The authority has
physical
explained
or
how
mental
when
condition
the
resulting in
disability pension will.
personal incapability to work like due to illness or so and so, and which requires demand. However, this is granted who have been injured or had by the nature of work, resulting in a permanent disability, which is not the case of the petitioner in the present case. Now, what is your reply?
Lordship. If admitted it, that the provision for granting of disability pension
But you are giving up invalid pension.
Lordship, because
Now I'm
As
asking you,
well-
are you giving up invalid pension or
I
not?
have not applied. In terms of for an employee to get an invalid pension, one has to apply. Along with
Understood. Are you, for the further present dispute, are you giving up
Lordship,
invalid pension or not?
I,
Also, she,
the petitioner is dire need. Lordship. Is in a very pathetic condition.
Mr. Counsel,
So the best,
everybody,
anything,
I understand everything that aspect, but are you giving up on invalid pension or not? And only sticking to disability pension? That is my question.
yes. Lordship, although I have claimed in my previous representations as well as in my legal notice for invalid pension, when the reply was finished to me, I have stated in my petition that the 2015 notification is prospective in nature and that it should not apply to a period when the petition was discharged from service. So that claim is still there, but this is the list that the petitioner deserves against the invalid disability petition offer. This man is living with his aged mother. And only to
But Mr. Imsong, tell me one thing. Prior to this, what was the situation? Prior to 2015, because the petitioner's right for invalid pension or disability pension arises in the year 1991.
Yeah.
You have come up with an office memorandum in 2015. So therefore, where you restrict that a person has to have 10 years of service. So was it done earlier? Whether what was holding the feet?
I'm not clear.
You see, you say in your affidavit that an invalid pension is a pension by which a person concerned who is discharged from service on account of medical ailment. You further say that the petitioner had worked only for 7 years, but not for 10 years. As such, he is not entitled to invalid pension.
Yes.
When you are saying this, one thing is also admitted that if the petitioner had 10 years, he would have been entitled to invalid pension, isn't it?
Inference.
It can be presumed from those what you are saying.
Inference.
Inference can be drawn in that regard. Then in that regard, you come up only in the year 2015 that a person has to have 10 years. But the petitioner's right for invalid pension accrue in 1991 when he was discharged. What was the rule at that point of time?
Yes.
Whether there was this 5 years or 10 years, the requirement was there or not. That is the first question. The second question is, if a person concerned becomes disabled, because you see, both can go together.
Basically,
An invalid pension can be there can be also a disability pension also. Now, a disability pension comes when a person becomes disabled because of certain aggravation of his work when he was functioning. Now, the judgment which the Learned Council relies out here in Davinder Singh. Okay. Whatever it may be. Well, I'll put it D Singh. So in D Singh, it has been stated that they were taking into account the provisions of the Army Rules or Act, wherein Rule 9, there is an onus of proof, and Rule 14 stipulates how it is to be regulated. On the basis of that, the court comes to a finding or opinion that when a person joins services, it is deemed that he was in good state of mind unless in the service records you mention categorically that this person is suffering from this or that. Thereupon, if any aggravation happens in respect to the health, it would be deemed that the person concerned had aggravated this disease or had the infliction of this disease during the period of his service. And therefore, the burden is upon the state to say that no, there is something on record that this person concerned was suffering from something. So therefore, my second aspect which I'm on there is as regards invalid pension, would these parameters which have been laid down by the Supreme Court in V-Sing, Supra, would apply? These are the two short questions, although put it on a very lengthy way. So I'll put it in my order. You get your instructions. Okay?
Yeah, Lordship, that is a worry, without which the presumptor cannot be decided. But you see, Your Lordship, here in this case, that is a technical aspect of the case. But everything has timing. So, Your Lordship, he was discharged on 1991, and as per the Indian Maturity Act, when the child is born, after attaining 18 years, he becomes mature and his citizenship is regularized as Indian again, reaffirmed. So here in this case, just seeing the unfair reading of the petition. Now 18 years after attaining 18 years of a child in India attain maturity. So also in the present case, the petitioner discharged in the year 1991, and he has represented his problem to the authority only in the year 2009, after attaining 18 years. Then after attaining 32 years, the medical board has conducted whether he has suffered from epilepsy or not. Is that the matter has to be taken into consideration by the court as and when the dispute is taken up? See, medical board, it was conducted on 7 March 2023. That is after 32 years.
No. Medical board have done in the year 1993.
1993.
Kindly see this. This is what I'm saying. Kindly see, this is the medical board's things. Medical certificate for invalidation at Annexure 2.
Yeah.
So this was done in the year 1993. The fact that he has, no, the problem which arises, on one hand, you are admitting one thing.
Yes.
That he was discharged.
Yes.
He was discharged because of his ailment on medical grounds, but he is not entitled to the invalid pension in view of the fact that he did not complete 10 years. That is your stand.
Yes.
So therefore, you are admitting to the medical board of 93 or 91.
91 was the.
You see, Mr. Imsong, I would have, in any other case, I would have been strict on the various other, but it is a case of pension. It is a case. And more particularly, if you see the medical appointment, medical board's certificate, kindly see this, which was done in 2023, Annexure 3. Okay.
Yes.
Here he says mental disorder. If it is a case, page 14, if it is a case of mental disorder, he is suffering from epilepsy and all this thing. These are what you call circumstances by which you can very well take it out and say that, okay, the petitioner could not have approached. And you see, the question is whether he has a right to get the pension for what he has done. That is the issue. It is not the question that this court, the pension matters, one has to be on more liberal, unlike land ownership. Because these are bounties. These are not bounties from the state. It is for the work they have done. So therefore, it has to, it's a right. Even it has been held to be a fundamental right in a recent judgment. So therefore, if it is a right, then obviously one has to give a more exponential interpretation. So I do one thing, I'll put a detailed order so that you can get the thing. And one fine day I will take it up when I am in Gauhati, where I'll see both of you. Not in Gauhati, from here. Because he has to obtain instruction, na? Let me put it down. Because you see, if I don't put it down today, you will have a problem. Okay? You will get this thing, don't worry. You will get in the month of
That is
September.
what at least I'm.
Your order, you will get it in the month of September. Don't worry. I'm only giving you a chance.
About
Now you get an order. It's if this court, it appears to this court that you should be entitled to both, unless he shows that there are some documents which were showing that if you don't complete 10 years, there were or 7 years or whatever may be, you were not. You could not have done it. Because he's admitting.
Cover my case.
He admits that you are otherwise entitled, but you have not completed 10 years.
So the question is whether there was any office memorandum or rules covering this type of nature. of
Yes. No, may not be here. Maybe in the center. It may not be here, but it may be in center because you are applying the CCS pension rules. So whether the government of India was happy because you are adopting the CCS pension rules.
Yes.
So you may have it now being brought in, but his right accrues in the year 1991.
Yes.
Chalo, let me dictate the order. That heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. I've also heard Mr. Im Song, the learned additional AAG, learned AAG, Nagaland, Government of Nagaland. The petitioner herein is aggrieved by the action on the part of the respondent authorities in not granting him the invalid pension as well as the disability pension to which the petitioner claims to be entitled to. Full stop. For appreciating the dispute, it is relevant to take note of the brief facts which led to the filing of the incident writ petition. The materials on record show that the petitioner herein was admittedly appointed on 21/6/1984 as a constable in the establishment of the commandant 2nd NAP Alishin.
Yes.
Full stop. The petitioner claims that during the period when he was serving, he was inflicted with the disease of epilepsy, and which became more severe and frequent on account of the workload. And he was therefore treated in the unit hospital at Alisin. Subsequent thereto, in the year 1991, on 19th of April 1991, the petitioner, after medical assessment being carried out, was declared to be unfit
By the unit doctor.
by the unit doctor and accordingly was discharged from service on medical ground.
It's here in the discharge it's written medical patient.
Subsequent thereto, there was a evaluation being carried out by the medical board on 22/6/1993, wherein it was mentioned that at that relevant point of time, the petitioner's age was 23 years.
This is subject to correct. This may not be correct. This is assessment of the medical.
Okay.
Otherwise,
Wherein it was certified that the petitioner was suffering from epilepsy. And was considered to be a disqualification for further employment in the office of the Commandant 2nd A NAP. The petitioner, upon his discharge, submitted a representation which was followed by another representation on 18/2/2009, claiming his dues, his pensionary dues. The same, however, was not responded by the respondent authorities. Situated thus, the petitioner again submitted another representation in the year 2023.
Legal notice in
2023, a legal notice in the year 2023. And a reply thereupon was sent to the petitioner that the petitioner was not entitled to invalid pension on the ground that he had not completed 10 years of service. Reference in that regard was made to the office memorandum dated 22/12/2015. The petitioner thereupon again submitted the representation which did not receive a favorable response, for which the petitioner has approached this court by filing a writ petition, the present writ petition. The respondents filed their affidavit in opposition. In the said affidavit in opposition, it was categorically stated that the petitioner was not entitled to the invalid pension on the ground that the petitioner had not completed 10 years of service. It is relevant to take note of paragraph number 8 of the said affidavit in opposition, wherein it was mentioned that the invalid pensions are granted to employees who are released from service due to physical or mental condition rendering them unable to work. It was also mentioned that the permanent incapability to work due to illness or injury unrelated to work, which requires recommendation of a medical board as in the present case. It was also mentioned that the disability pension is granted to employees who have been injured or have their health aggravated by their nature of work in their service, resulting in a permanent disability, which is not the case of the petitioner in the present case. This court, on the basis, the petitioner thereupon submitted a reply, filed an affidavit in reply, wherein contested the averments made in the affidavit in opposition to the effect that the petitioner was not entitled to invalid pension on the ground that the petitioner had only completed 7 years of service and not 10 years of service. It is the case of the petitioner that the office memorandum of the year 2015 could not have been applied retrospectively in the case of the petitioner, inasmuch as the petitioner was discharged from service in the year 1991. Further to that, it was also stated that the petitioner had developed as well as was inflicted and aggravated, inflicted with the disease of epilepsy, which became aggravated during the period when the petitioner was working. In this regard, this court had duly heard the learned counsels appearing on behalf of the parties. Mr. So-and-so, the learned counsel appearing on behalf of the parties made twofold submission. The first submission is that as there was submitted that invalid pension is regulated by the CCS pension rules, which do not mandate a period for getting the benefit thereof, benefit of the invalid pension, period of service for getting the benefit of the service. The Learned Council submitted that in the year 2015, an office memorandum was issued. However, the said office memorandum cannot be said to be applicable to the present facts, taking into account the petitioner was discharged in the year 1991. The second submission so made by the Learned Council appearing on behalf of the petitioner, relying upon a judgment of the Supreme Court in the case of Dharamveer Singh versus Union of India, reported in 2013 7 SCC 316, and submitted that the petitioner having entered in the employment would be deemed that the petitioner was in fine health. First, any aggravation or infliction of a disease during the service and on the basis thereof a petitioner being discharged would result in the entitlement of the petitioner to the disability pension. And therefore, the Learned Council submitted that applying the law as laid down by the Supreme Court in Dharamveer Singh Supra, it is for the respondent herein to show that there were contemporaneous records maintained that at the time when the petitioner had entered into the service, the petitioner already was inflicted with the disease for which the petitioner was discharged. First, this court have also heard Mr. Imtim Song, the learned AAG, who submitted that the petitioner having not completed 10 years of service, the petitioner was not entitled to the invalid pension. And further, it was also stated that there is nothing on record to show that the petitioner had developed any disease during his service, or his health disease which he was already inflicted was aggravated. And these aspects of the matter cannot now be agitated, taking into account that already 34 years have elapsed from the date of the discharge of the petitioner. First, this court, upon hearing the counsel for the parties, have put two queries upon Mr. Imtim Song, the learned AAG. Number one, whether the facts narrated herein above would show that the petitioner was discharged from service on 19/4/1991. First, whether there was any provision prior to the office memorandum of 2015 which restricted granting of invalid pension to those persons who have been discharged prior to 2015. This query is being made taking into account that the CCS pension rules duly applies to the state of Nagaland. And Rule 138, na? Rule 38 is the relevant provision which mandates the entitlement for invalid pension. Number 2. This court have duly perused the judgment of the Supreme Court in the case of Dharamveer Singh Supra, wherein the Supreme Court categorically observed that the onus is upon the employer to show that the employee already had an pre-existing disease prior to entering the service. And it was further observed that if there is no contemporaneous records maintained of the time when the employee had entered into service, then it shall be presumed that the employee was inflicted with the disease, or the disease have aggravated on account of the work he was asked to endure to. Under such circumstances, this court therefore inquired with Mr. Intim Song, the learned AAG, as to whether the same principles can be applied in the facts of the instant case, taking into account that in the judgment in the case of Dharamveer Singh Supra, the Supreme Court was interpreting the provisions which would be applied to the armed forces. First of all, Mr. Intim Song, the learned AAG, next submits that he would obtain instructions in that regard. First of all, list this matter again on 16th of September 2025.
Lordship, if it is not later done, because if I fail to obtain the instruction again, that proceeding will be frustrated. So it will be set on 23rd of September.
On 23rd of September at 2 p.m. First stop, taking into account that the matter has been substantially heard, the registry is directed to place this matter, and the registry is directed to, and I'm taking into account that the matter have been substantially heard, and on account of the instructions awaited, the matter could not be disposed. And further, any further delay in disposal of the present matter would be further aggravating the cause of the petitioner, who is already under difficulties. This court directs the registry of this court to place this matter before me in the principal seat, and the matter would be taken by the video conferencing mode, facilities of which shall be duly provided to both the councils to address by the registry.
Just point out, in pursuance to the judgment of the Supreme Court, this honorable court, by an order.
Mr. Counsel, you want to put it, okay? We will look into it. I think you'll get it on 23rd before vacation.
Yes,
I will pass an order. Put this. Then you'll get both, because you don't give up invalid. You have both.
Lordship, the only difficulty that I faced was because the invalid petition I have to.
We have to take into account that you are not suffering from leg or hand. You'll have to take into account the mental disorder.
I appreciate it. Much obliged.
For orders, item number 1.
Yes, Mr. K. Gogoi.
Lordship, yesterday I have filed affidavit as per my lord's direction. We have stated in paragraph 6 the reasons, Lordship. I have sent it to mail also, Lordship.
Yes, I've read it. Where is
Yes.
it? Yes, I've read it.
Lordship.
Yes, Mr. Datta, what do you have to say?
My lord, 5 crores, my lord, we can, my lord.
Huh?
5 crores, my lord, I am agreeing, my lord.
Agreed.
Agreeing, my lord.
Okay. Then I think because of the corrigendum, we can close it.
Lordship,
my
Lordship,
lord.
Lordship.
Things happen good sometimes.
Lordship.
My lord.
Lordship.
Mr. N.J. Datta, the learned counsel appearing on behalf of the petitioner. Heard Mr. N.J. Datta, the learned counsel appearing on behalf of the petitioner. And Mr. K. Gogoi, the learned additional senior government advocate, who appears on behalf of the respondents. First up, pursuant to orders being passed by this court on 14/8/2025, 28/2025, and 27/8 and 28/2025, and 21/8/2025. The state respondents have filed an affidavit stating inter alia that in terms with keeping in tune with the provisions of clause 4.1.2 as well as the Assam Procurement Preference Policy 2021, a corrigendum has been issued on 26th of August 2025, whereby the minimum average annual turnover for the last 3 years, as mentioned in clause 4 of the additional terms and conditions in connection with tender number PRI.634353/PT/23 bracket supply of dietary articles under Zone-5 jails of Assam during the financial year 2025-26 bracket close dated 6/8/2025 as ₹5 crores in respect of micro, small and medium enterprises bracket MSME bracket close. The learned counsel appearing on behalf of the petitioner submits that the petitioner has is no longer aggrieved with clause 4 of the additional terms and conditions of the said tender. Taking into account the above, nothing further remains to be adjudicated upon, for which the instant petition stands closed. Interim orders, if any, stands vacated.
Oblige, Lordship.
I am obliged, my lord, deeply obliged.
Oblige, Lordship.
For hearing, item number 19.
Yes, who is going to argue? Yes,
Lords,
Mr.
I'm appearing for the petitioner, my lords.
Yes, tell me.
Lords, to begin with, my lords, lordship, I've spoken to the parents. They are very much in pain because of the condition of the child.
It is not that they are gaining anything out of their submissions before the Honorable Court. Not the only thing I would like to start with is the order that was passed on 17th of July. May kindly have para 7 for a minute, because that order was passed after complete submissions made by both the sides and a judicial order was passed. My lords may kindly consider that order for a moment.
7th of
17th of July in IA 65.
65. Yes.
Your Lordship will have, Your Lordship knows the background. Now, my lords may kindly have the relevant para 7 of this order. So
Yes.
there are two orders. I'm talking about, I'm referring to the order which is running into 7 pages, and it is passed in IA 65.
Yes.
My lords may kindly have para 7 of
Yes.
this order.
Hmm.
Lords, should I read it, my lords?
Yes.
Nonetheless, given the seriousness of the allegations and its potential impact on the integrity of the court proceedings and the petitioner's constitutional rights, the following directions are issued. The Registrar Judicial shall verify whether the interlocutory application in question bears the signature and authorization in compliance with the rules and whether any irregularity appears on the face of the record. The Judicial Registrar shall submit his report in a sealed cover within 3 weeks. The sealed cover envelope shall be tagged with the main writ petition. Point 2, my lords. Since the complaint filed by the applicant before the Bar Council, Nagaland, Mizoram, is stated to have been completed and the order is reserved, the Bar Council is requested to expedite the inquiry and take appropriate decision in accordance with law, preferably within a period of 3 months from the date of the receipt of copy of this order. And now, the Roman 3, my lords. If the petitioners are advised to seek correction or recall of any prior order passed on the allegedly authorized interlocutory application, liberty is granted to do so by filing an appropriate application. In this regard, the counsel for the applicant submits that an interlocutory application has already been made, which is registered as IA 58.
Yes.
So, my lords, the report is with my lords. The point here is, my lords, that lords may kindly have the report.
Yes. What is the report?
Your lordship should be in the file.
Why did you file this application in 2024?
Lords, I have given the reason. As soon as my lords, because I was not appearing in person by that time. So as soon as the petitioner, my lords, they came to know, they filed it at the earliest.
The petitioner came to know on 17/7, when was the order passed, whereby it was the directions were issued for striking out. That happened in the year 2022.
Yes,
Why
my
did it
lord.
happen in the year 2024?
Lords, they appeared in person on 4th of July 23, my lords.
Mr. Jain, tell me one thing.
Yes, my lord.
There were orders being passed when that advocate was appearing.
Yes, my lord.
Those orders were in the interest of the child.
Yes.
It may not be in the interest of the pecuniary benefits of the parents, but they were
Yes,
in the interest of the child.
Yes, my lord.
Do you want that this court should also recall those orders?
Lords,
Because you cannot
point.
pick and choose.
Yes, my lord.
You have to also take note of one thing. as regards any deficiency in service by the Christian Medical College or whatever name it is.
Yes.
This is an aspect if we look into the judgment of Jacob Matthews.
Yes, right.
It has to be preceded by a medical opinion.
Not only
Things have to move. Now, these are facts which can be adjudicated before the consumer forum, but not in a writ proceedings. As to whether there was a negligence on the part of the whether there was any, if you want that this court should adjudicate on a question of constitutional thought, that is another aspect of the matter. But the fact remains that as regards the negligence and all, if there was a negligence on the part of the Christian Medical College, you have the liberty to approach the consumer forum in that regard. The prime reason why this court had entertained the incident proceedings was taking into account Article 21 of the Constitution, the life of a child who was under distress, taking into account that the Christian Medical College at that point of time had stated that let this child go away because they are not making any payment and we are not in a position to provide any further medical, medical services to their child. It is under such circumstances, this court, while hearing the matter because I was the first person who had taken up this matter.
Yes.
Then taking into account that Mulchan's judgment, I asked them that look here, forget about the money, we'll take care of the money, how it is to be given. Should we employ the National Legal Services Authority or any other matter, or we can entrust the state, or we can very well say that when you have taken the land from the state, it is the bounden duty of the Christian Medical College to look after the child. These are aspects were being taken on the aspect of 21, not on the aspect as regards the remaining prayers can be very well looked into before the consumer forum. It is under such circumstances these orders have been passed. Now, in all fairness, I would therefore implore upon you as well upon your clients to give up these aspects. Go ahead. I will give you the liberty as regards those prayers insofar as you want to go ahead. Before the consumer forum, go ahead. Because you see, you should not bring a case where you are asking that a right under Article 21 is being violated and a child is in the danger, that you should not amalgamate it with certain pecuniary benefits which you seek. Yes, if you seek any, if you say that they have committed, they are responsible to provide you due care, yes, this court is going to take it up. But not for the purpose of looking into whether there hasn't been a negligence and all. This is within the purview of the consumer forum. These reliefs which you have sought for and which you want to reinstate, I will implore upon you to advise your clients to go, that I can ask you, these reliefs can be, you can take it up before the appropriate forum, that is the consumer forum. There's a consumer forum, where evidence can be laid, everything can be done.
Yes, madam.
As regards this. As regards the child in question, let this court look into it. We will look into it, how we can take due care by judicial orders upon the child. So that is what I said. Unless, if you want to go on a different tangent unnecessarily, don't go into that. You see, there are many aspects. Just let me give you an example. When I first started taking up matters out here, you have matters out here where preventive detention matters are being filed. As regards writ petition, habeas corpus matters are filed. Now you are aware of the fact that a habeas corpus matter on a preventive detention is that the person is in preventive detention. But you find here affidavits being filed. Affidavit being filed by the detainee, it cannot happen. But you have to excuse those. If it was in the principal seat, it is a different aspect of the game. But you cannot employ the same aspect everywhere. So therefore, I was asking you, ask your client, don't go into all these things. I'll pass an order to that effect. As regards the other reliefs, you can very well take it up before the consumer forum, the state or the national consumer forum, wherever you want to take it, you take it. You may go to Delhi, you are in Delhi, file like the valuation is 1 crore. I think it's 1 crore.
So as per the new act, now we have to go to the district forum because the amount paid is much less than 2 crores. So it has to be as per the new act.
And you are also aware of the teeth which have been incorporated into the consumer forum, the consumer act now. Now earlier it was a bit teethless. Now it has the more teeth has been given, and there are many avenues available. So these aspects can be very well looked into by a particular authority or particular forum where all these disputed questions of fact as to whether there was negligence or not can be very well looked into. It may be a thing that these Christian Medical College may be also insured, for which the insurance company has to be brought in.
Yes.
These are many aspects which you may have to look into. So therefore, I say, let us continue this repetition for the benefit of the child. As regards the pecuniary thing and all these things, let it go before the consumer forum.
The Lordship can segregate it, but I have only one thing to say, Lords, because the parents are before your Lordship today. Lords, may kindly give them 5 minutes so that at least.
Yes, I give you that. We'll hear again at 3 o'clock.
No, my lords, not me. Your Lordship can, they are sitting in front of the court. My lords can allow them for 5 minutes.
You see, when the matter was taken up and initially moved by Ms. D. Ghosh, there are two aspects when a matter is being taken up. If we had certain orders, I can pass against the Christian Medical College, taking into account that the child is in distress.
Yes.
But if you amalgamate the distress with certain pecuniary benefits, then it gives a flavor that you want certain pecuniary benefits and aspects. So therefore, I asked the council at that point of time, you take out these so that give me the way by which I can take up this. As regards your relief, if you want to seek any relief or compensation from them, go ahead. There's no quarrel. I give you the liberty for going ahead with them. As regards all the reliefs which you have, as regards that. But let us only concentrate out here in respect to how we can give due care to the child through them or any other institution. That is the issue. Madam, I have to appreciate one thing. If we go into all other aspects, you are just derailing the proceedings unnecessarily. That all these things can go on, but this is not going to help you out.
Yes.
You go ahead with this. Let us take for the benefit of the child. I give you the liberty as regards all the other reliefs which you have, go before the consumer. I can recall that order and give you the liberty as regards all these reliefs can be gone before the consumer forum, wherever you go. The consumer forum would be the best option, taking into account that after the recent consumer forum gives a lot of opportunities and it has a lot of teeth by which those orders can be complied with. A person, if it is not complied with, can be sent to imprisonment. These are many aspects by which you can get it done. So therefore, don't press on these two. This is my request for you. If you want to do it, you can go ahead and do it. But then I will incorporate it, and then the flavor of the repetition goes into a different aspect. Then you see the court, if any orders is being passed where any amount is being challenged, you cannot get any amount of these which you are asking by way of a repetition, because it is a question of evidence as to whether there is a negligence or not.
Yes.
Unless your lawyer may explain, if it is a case of res is per locator, then obviously, when on the facts of the case, it is apparent that there is a negligence, it's a different aspect of the matter. Then the court can implore an aspect of constitutional thought, but give you a little damages of some amount, but you can get the actual damages before the district court.
Your Honor, if I may speak.
Yes, please.
Your Honor, initially, we also thought that compensation we should file in the consumer forum. Our advocates at that time told us, because she had thought if I may give you a copy, she had already fought a case of medical negligence in this very court, filed under the same constitutional article 226, asking for compensation, and the court went ahead with the case, looked at the merits from both sides, hospital, doctor, and victim, and even awarded compensation.
How much?
I think is 40,000.
Do you want the 40,000?
I'm not saying I
You are
want
asking
40,000.
much.
Every case
It
goes.
is after all a case of negligence of a
Yes.
child which led to it amounts to what you call a negligence of a child of taking due care, which led to an incapacitating the child for his whole life. So if you certain aspects, I'll just tell you, there are judgments of Ayush where the Supreme Court have duly passed, but these are all consumer forums where amounts have been given to the extent of 1.34 crores. These have to be looked. There was one case, yes, in one of my matters, I passed the judgment on a constitutional thought. There was a case where it was apparent that the child was all along fine. The child was injected with a vaccine. And this resulted in the child developing a disease called the ADEM. And because of that, she had lost her spinal movement and all these things. And because of that, I passed an order. But I passed the order after 14 years. The matter was filed in the year 2014. And the petitioner who was there, she only asked for that my bill may be paid. I not only directed payment of the bill, all these things have happened, but I joined as in 2022. I joined out there and passed an order to that effect that she should be given a minimum wages, which is given for the labor for all throughout her life. And initially, till she doesn't become a major, it should be given to the father. And also the requirement of a nurse. But this is on a fact which is an admitted fact. These are admitted facts, but here they are not admitting any negligence. So, madam, therefore, I implore upon you, give up all these things. We keep this. I give you pass an order that all these reliefs which you are sought for, and which was withdrawn, you shall be at liberty to file appropriate application before the District Consumer Forum if so applies. And we close these two applications and proceed seriously on this. You see, I'll tell you what. In matters pertaining to, nobody wants to go or endure the trials.
Yes.
In the trial proceedings. Somebody wants some money from somebody. Or somebody said that, okay, I'll be making a payment to you if you do this. This is absolutely a contract. If you go for the purpose of breach of contract, you have to go to the civil court. It will take years. And because of that, the lawyers come out, they file criminal proceedings. But at the end of the day, the person may be imprisoned, but the fact that he would not get the money.
Yes.
So this is how it is being done. Nobody wants to. But here in the consumer forum, you can appear. You don't need an advocate. You can very well appear, say all this negligence. If you want to have a lawyer, it's a different thing. Even you can take the help of a legal counsel also. All these things. But you can very well appear and say, because in the consumer forum, you don't even need a lawyer. You can very well appear, bring out all these things and go ahead. And your lawyer is there, Mr. Jain, who can help you out in the consumer forum. So you can very well go ahead and do out there. Let us close this chapter, proceed with the petition so that the child gets the best benefits, which I can pass. Okay? You are here in Kohima. We'll have it on Monday if you want again. Think about it, both of you. But this is my suggestion. As you are here as in person, petitioner in person. So this is my suggestion. Think about it. But this is not going to do any help to you. That is my only say. I will bring in, I'll give you the liberty. That order, I will recall it, whereby all these reliefs have been taken away. I'll say that these reliefs have been, the petitioner herein would be entitled to claim all these reliefs, and the period during which the instant proceedings from that order date till date be excluded while computing the period of limitation. Because the limitation is also there. So these things I'll do. If you want, I can have it again on Monday. You inquire with your advocate and then come back. But the thing is, you have, at the end of the day, you need a child to get the benefit. And I will try my best to pass appropriate orders to that.
Lords can keep it for Monday, I think. That would be better. My lords can kindly keep it for Monday, my lords. I'll discuss it with them.
Okay, Monday? Okay, this court heard Mr. Ed Jain, the learned counsel, appearing on behalf of the petitioner, and Mr.
Samuel Abraham, R1.
You are
I'm representing R1 hospital.
Oh, you are appearing for the hospital. Okay.
Yeah, first day. Yeah.
The so-and-so who appears for the respondent number 1, and as well as Ms. So-and-so, as well as the petitioners who are also represented, who are also present in person. Upon hearing, both the petitioners who are present in person have sought for some time to rethink on those applications which have been filed. And accordingly, this court fixes the matter on 1/9/2025 at 2 p.m. 2 p.m.
Thank you.
Mr. Jain, explain.
Please, madam.
For orders, item number 11.
Yes, Mr. Imsong, what is this?
Yes,
Review? What have I done wrong?
Lordship, I have got a sufficient time to file a affidavit of opposition. But the Lordship here.
What review? My order.
No, not review.
There is a review
Review is
petition
already
filed.
disposed of.
Review disposed.
Disposed.
Where
And
is the
now,
review here? Now this is the WPC.
yes, we have to file a affidavit of opposition.
Reservation in vacancies. Urgent for stay. No stay granted also.
No stay.
What do you want?
Lordship,
Long order pass.
I need some more time, even though I have got sufficient time to file affidavit of opposition. Your Lordship, the matter is very, very delicate and sensitive. They are claiming for the reservation by one tribe. Initially, there were 6 tribes. Those who are enjoying the reservation policy. And 6 tribes, they were distributing 25% from the entire state. Now, by the notification dated 2022 January, out of that petitioner tribe, another tribe, sub-tribe was recognized as a tribe. So, for which they are claiming for their own benefit. But the thing is here, we have for alternative arrangement, we have already chosen the alternative arrangement. But the thing is, there are 6 tribes are there. So we cannot touch the 6 tribes, and we have an again working. And in the meantime, another reservation policy has been initiated by the.
I remember this matter, I've heard it somewhere. Someday it came up before me. And you say that there is a big problem.
Yes.
In the matter came up before me someday.
I think last year.
Last year the
Yes.
matter came. I remember.
Because it was a
There is a very big issue as regards it needs a
Yes.
political solution to that.
And now.
But
government
that
has-
doesn't mean that Mr. Imsong, when the matter is before this court, you are not going to file the affidavit.
So.
Meaning that, but if you are not filing the affidavit, means you have nothing to say.
No. We have, but your lordship, considering all those situations, local situations. So, and by taking into account that recently government of Nagaland has adopted one, scheme in order to see the policy, entire policy. So within a short time, I can file the affidavit, but why it was delayed? Because of this local situation. As I stated earlier, affidavit could not be.
No, whatever the situation it
Yeah.
is, you have to place it by way of an affidavit.
Yes, yes.
So put it.
Yeah.
You cannot say that there is a big problem because of that I am not filing. You have to
Yes.
say why you are not giving. The petitioner has asked for a right.
Yeah, before Lordship to do so, I.
Okay, when do you want to file it?
After 2 weeks.
Mr.
Next day.
Imsong, one thing.
Yes,
Today in that matter where I have passed an instruction,
yes.
can't we have it next week? You see, you are to only show the law. You don't need to have any instruction. Why I am saying it, unnecessary carrying the file there.
If the Lordship, if it's fixed on
Thursday, if we
yeah,
can.
4th September.
You inform him.
Okay.
Huh? We'll fix it on Thursday. The last matter I took up before recess. You were there?
Item number 17.
Item number 17. Put it on 4th of September. Huh? At 2 p.m.
Okay.
Okay.
I'll inform.
So then you just get that, whether there is there. This is the law. It is only the law. Whether he
Yes, yes,
if he has to get it, you have to get it. Otherwise, no. Because carrying the file out there, the problem which happens in Gauhati is when I take up the matter, none of the lawyers here is appearing. And therefore, I had to get one matter which I took it out there again back here.
Okay.
So we'll have it on 4th. You just get that instruction, these two. Chalo. And when do you want this?
After 2 weeks.
Okay, list this matter again on 18/9/2025. So in the meantime, a final opportunity is given to the state to file the affidavit on or before 15th of September 2025.
For orders, item number 12.
Yes, Mr. Lordship.
Hmm.
Lordship, here I'm yet to receive instructions, so kindly grant me 3 weeks of.
Compassionate appointment.
Lordship.
No. Compassionate appointment I don't give. I give only 1 or 2 days. Here he is asking compassionate appointment. Your instruction should be whether he is under consideration or not.
No, Lordship.
If he is under consideration, what is the number in the serial? That's all. I don't need more. Isn't it, Mr. Simple. What do you need? You just get what is there, an instruction, and dispose it up on that basis. No affidavit file required. You only have to get that instruction as to whether that particular person, the petitioner's application is under consideration or not.
Lordship, here the petitioner is in serial number 6.
Oh, that is it. Finished. It is under consideration. Then the petitioner's grievance is done. We dispose it of. That's all. You see, Mr. Counsel, you cannot consider the petitioner before any other. If he is in serial number 6, you have to consider as per serial number 6, whenever his chance arises. So that's it. Petitioner, this court cannot direct you to appoint the petitioner, jump from 6 to 1. No. In my opinion, I don't have that jurisdiction. So we dispose it of.
I'm appearing for private respondent number 26.
Why?
Here the petitioner has multiple prayers.
To
pause and set aside the appointment orders of the private respondent number 45, 11 to 32.
Oh, many petitioners, why?
Not many respondents.
Why are you making so many people have respondents?
As per the scheme,
Ah.
the ceiling is 50%. Vacancy arising in a year.
Ah.
Now, what has happened, I have submitted my application on 18 January 2019. Now, 6 years. Within the 6 years' time, the department has appointed 48 appointments, grade 3, grade 4 lodging, without complying with the scheme formulated by the state government lodging. And I have obtained information from the department. It appears for the last 6 years, only 2 appointments were given.
From compassionate appointment.
And if this practice goes, lodging, I'll remain forever serial number 6 lodging.
This can't happen. And this matter has been going on for a long time.
No.
Yes, 2025. And it was filed on 28/5.
Lodging.
Last how many years?
2019.
He's agreed for the last 6 years. Why don't you give him appointment?
So Lordship, I need to take instruction, so kindly grant me 3 weeks so that I can find my affidavit. Since here they have included 28 of them,
Huh?
so I need to get a further instruction from the department, Lordship.
The order which was passed by Justice Sema in the month of June 2025 is clear and specific. Why do you need more instructions? His only case, as I could see from what Mr. Jamil say, that look here, you have a scheme whereby you say that 50% would be appointed from compassionate appointment. There's some scheme. For the last so many years, 2019, he has submitted this. And in the meantime, you have appointed 48, and against that, only 2 persons have been appointed on compassionate. He says that he would never get the chance of being appointed if this goes on like this. And after that, you would not be able to apply the 35 years thing also. You'd never get 35 years. Which is as per Nagaland Public Employment Act. When? Next week?
Or 3 weeks.
No, 3 weeks too much. In Nagaland, 3 weeks is very. You sought for learned government advocate Mr. M. Longpoma with the
Lordship,
consent
I'm
of the I had
here
prayed
for-
for adjournment, least after 3 weeks. So many adjournments, 3 weeks. How many times do you require? People will lose faith in the judiciary that look here, these people are just sitting out here not doing anything.
Lordship, here I'm representing respondent number 1, 2, and 3 only. So the rest,
He is appealing?
I know, I'm only appearing for sole respondent, respondent number 26 only.
Okay, Mr. Muazzamir shall not insist upon other appointments being cancelled. He wants his consideration. Then forget it. Then now, we don't require you. No, tell me.
Lordship, 3 weeks.
No, 3 weeks. Next week. Why haven't you considered? Why haven't you considered the case of the petitioner? You are to give an instruction as to whether you are acting as per the policy. I'm putting a long order so that the matter comes up again on, I don't have time next week. 1 day is less, so it's very sad. Okay, next 2 weeks. Can't help you, Mr. Zami. No time. So many matters are getting listed. Okay. Heard Mr. Muajami, the learning counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent state. And Mr. So-and-so appears on behalf of the respondent number
26, respondent number 26.
20?
26.
26. The case of the petitioner herein is that the father of the petitioner expired on 1/1/2019 while serving as a peon class 4 non-gazetted under the establishment of the Directorate of Soil Conservation with temporary headquarters at Meluri. The grievance of the petitioner herein that though as per the office memorandum dated, where's the office memorandum?
1709.
1709-2015. The that there are certain reservations made in respect to direct recruitment vacancies in Group C and Group D posts. Full stop. The learned counsel appearing on behalf of the petitioner submits that in the last 6 years, more than 48 persons have been appointed against only 2 persons appointed. 48 persons have been appointed on direct recruitment basis to Group C and Group D posts. But only 2 persons have been appointed in terms with the office memorandum dated 17/9/2015. This court inquired with the learned counsel appearing on behalf of the respondent as to whether the petitioner is under consideration. The learned counsel for the respondent state submits that the petitioner is been placed at serial number 6 of the said list. First of all, this court further inquired as to whether there has been compliance to Clause 4 of the Office Memorandum dated 17/9/2015, which stipulates the ceiling for compassionate appointment. The learned counsel appearing on behalf of the respondent state submits that he would obtain necessary instructions and file an affidavit in that regard. First of taking into account the above, list this matter on 18th of September 2025. 19th of September 2025. The affidavit be filed by the respondent state without fail by 15th of September 2025. And in the said affidavit, it would be the respondent shall clarify as to whether Clause 4 of the Office Memorandum dated 17/9/2015 have been adhered to since the filing of the petition by the petitioner seeking compassionate appointment.
For orders, item number 13.
On the last occasion, this board has. May I please, my lord?
Yes.
Lordship, on the last occasion, while issuing the notice of motion, this honorable court has also asked me to get instruction as with regards to the listing of the shortlisted candidate that has been mentioned in the notifications 8/8/2025. Lordship, I have sought the instruction from the department, and Your Lordship, they have instructed me that the directorate office has, without verifying the documents straight away, has sent it to the government. And therefore, it has been sent back to the directorate to verify those documents and resend it back to the government, Your Lordship. That as far as the instruction, that part is concerned, Your Lordship.
On the said date, the learned senior government advocate shall inform this court whether the list of shortlisted candidates have been published.
Yes.
On the date mentioned in the notification, and if they are published, is also requested to place a copy.
Yes.
So you say that it has not been published?
No. Yes, it has not been published as of date, Your Lordship, due to
Yes, Mr. Jamil, what is your case?
Also, my case is Lordship. This matter, Lordship, it has been monitored by the Honorable Apex Court in the sense, Lordship, there are certain directions we issued from time to time. And this has started in the year 2016, where a case was registered at WPC number 132 of 2016. Now, this was filed for the state of UP and Punjab.
No, what is the matter about?
Special teachers, Lordship. The requirement to have special teachers for children with special needs, Lordship.
Okay.
So, the Honorable
And
Apex
who are
Court-
you? Who are you?
Lordship, we are the special educators in the state of Nagaland, Lordship.
Okay, so they have initiated some recruitment process.
Correct.
And there you have not been shortlisted.
Lordship.
But the question is whether you have been shortlisted or not has not yet been known because they have sent it to sworn verification.
Yes, Your Lordship, not only that, the issue involved another thing, Your Lordship. As per the guidelines provided by the Rehabilitation Council of India, RCI, there are 3 groups mentioned, which.
So, Mr. Angami, wait.
Yes,
This is a matter, first time it has come.
Yes.
After notice.
yes,
It is only given on 22/8 just
Correct.
last week.
correct.
We do one thing, we take it from the statement which you have made that there has not, the shortlisted candidates have not been notified.
Yes, as of date,
There will be some time
Correct.
as certain verifications are required.
correct, man,
Now, in the meantime, you file your affidavit,
correct,
bringing on, you record your stand.
Lordship.
And any appointment so made shall be subject to the outcome of the petition.
Your Lordship, as far as the present notification is concerned, Your Lordship, it appears that probably the petitioners might not have a locus to challenge this, Your Lordship. So yes, but
So keeping the locus of maintainability of the
Yes.
petition open?
Your Lordship, yes. So allow me to file my affidavit, bring in all those on record. Your Lordship.
Absolutely.
But if I may just for a moment. In the month of March 2025, Lordship, the Honorable Apex Court has given a direction to all the state and the UTs in the country, Lordship, to conduct a screening, Lordship, screening of all those who are in service, Lordship. There was a specific direction to conduct screening tests and find out whether they're eligible to teach, Lordship. That was one specific direction. The second direction was to identify post and come up with a sanction post so that that post can be advertised, Lordship. Now my concern is, Lordship, in compliance of that direction, the state government, they have initiated a screening test. Now they have issued a notification on 8th of August this month. And the eligibility criteria shown as B.Ed, Lordship. Whereas the present petitioners before us all for a D.Ed, Lordship. Now, D.Ed, Diploma in Education, Lordship.
Diploma in education.
Yes, diploma.
And all the petitioners are?
Diploma vouchers and the notification has invited candidates only B.Ed.
Bachelor.
Yes, Lord. Now they are in the B.Ed
So
qualified.
you are
candidates.
challenging the qualification.
Lordship, my.
Because otherwise you don't become eligible.
No, I'm not challenging the qualification. My concern is, Lordship, even the B.Ed, they are qualified to teach primary and upper primary as well as kindergarten. Now they have invited only those candidates who can teach secondary and higher secondary. Whereas in the state of Nagaland, we have only 42, a total of 42 teachers. And the state has identified 4,000 plus children which require special needs. So that's
And what is the teacher-student ratio?
the ratio is 1 to 10 for primary, upper primary, and for secondary and higher secondary is 1:15, Lordship.
So you mean to say they will require around 100, 400?
Exactly, Lordship.
We have a good chance.
Yes, Lordship. But they have not invited us to face the screening test, Lordship. I want to face the screening test, Lordship. My prayer is not to select me. I want to undergo the test. If I'm qualified, I'll continue to teach, Lord. And the second exercise is yet to be taken by the state. Identification of.
Now, how many of the candidates you are calling for interview?
Your Lordship, it's 34.
How do you take care of that situation?
No, Your Lordship, 34 only for a particular category of teachers. There are other categories of teachers, which the department is going to also call for an interview, Your Lordship. I will bring all these things.
I think you do one thing.
Yes.
Bring that aspect.
Yes.
Because that means there is still a chance.
Correct.
For them also to.
Yes. And we are following the guidelines that has been provided by the.
Because Mr. Angami, the problem is any stay on this or anything, any purpose, any interference at this stage could impact in the recruitment process.
Correct.
Which would affect later on, which would also impact on the directions and compliance to the directions passed by the Supreme Court.
Correct.
So let you go ahead.
Yes.
But we report that you are going ahead with further.
Yes. Your Lordship, since the petitioner was seeking stay on this, though the court has not asked me to receive this instruction, but I have asked it from the department. And they have categorically sent a letter to me showing that they are actually proposing some of the permanent teachers convert that post into this special teacher post so as to recruit the special teachers, Your Lordship. We are taking steps on it.
Promise lordship, this matter is fixed today for a apex court lordship. By order dated 15th July 2025, all the state government, state and union territories, they're directed to furnish the steps taken report.
Your lordship, in that aspect,
Because otherwise, if I pass any order,
Lordship, I
this will
understand that.
have an impact and they will
I
take
understand.
and in fact, this would be harming the special needs children.
yes, correct, correct. Correct.
So, and you give and this is a lever for the state not to comply, saying that Gauhati High Court has passed an order.
Your lordship, no, we are not going to do that, but of course, your lordship, we are sincerely working on it, your lordship, and then we'll be as
Okay,
yes.
heard Mr. N. Angami, the learned senior government advocate, who submits that there is no notification yet published in respect to the shortlisted candidates, taking into account that there is a further process of verification going on.
Lordship.
He further submitted that though in the qualification eligibility criteria for appearing in the screening test who have been put at B.Ed,
Yes.
that the same is required for the purpose of the particular students to whom these teachers are to be required to be
Yes.
appointed.
Yes.
However, he further emphasized that taking into account that there are a lot of special needs children in the state of Nagaland, he has also been instructed to inform this court that there is a proposal on that there's a steps are also being taken for the purpose of recruiting further more teachers.
Yes, in other two categories.
In other two categories, taking into consideration the necessity and the eligibility criteria would be dependent on the necessity in respect to the other necessity, would be dependent upon the necessity, would be dependent upon the requirement for the other two categories. It is the opinion of this court that this court, Mr. Muajami, the learned counsel appearing on behalf of the petitioner, further submits that the Supreme Court is also looking into aspect, is in session of the, is also in session of the aspect, session of, have been time to time passing appropriate directions for due compliance, for the appropriate directions for the recruitment of teachers for teaching special needs children. And he further submitted that as per his instruction, there are more than 4,000 special needs children in the state of Nagaland. Taking into account the state's submissions so made by the learned counsel appearing on behalf of the state respondents, it is the opinion of this court that the same be placed before this court by way of an affidavit. List this matter again on when 22nd of September.
Yes,
affidavit be filed by 17th September.
Deeply obliged, man.
I've recorded that they will be going for further. Because you see, the problem arises is regarding qualification, but eligibility. Eligibility becomes very difficult unless we see any affidavit.
Obliged.
For unlisted motion, item number 20.
Yes, my lord.
Who is your
This
respondent?
morning, I have submitted that it's because of 5 days to submit the written statement, but it's not that logic. The actual purpose of this, filing this case before this honorable court is that the petitioner was not reinstated. And as same as before, this is the third round of litigation, Lordship. They did not reinstated the petitioner as per this honorable court's order, that is, my lord, will kindly come to page 25F.
When did you receive this? This
Day
document,
before yesterday on 27th,
you received it on 27th.
27/8, yes, day before yesterday.
Then why you are not filing your reply?
Lordship, here, what I want to appraise my lordship is that as per this honorable court's order that is dated. My lord will kindly come to page 27. This honorable court placing a letter before this honorable court stating that they will reinstate the petitioner. Basing upon that, my lord has passed an order for reinstatement of the petitioner within 15 days. Now, they five, 6, and 7, lordship, the relevant portion.
Yes, madam, tell me.
Yes, lordship.
No, not you. How are you going ahead with these proceedings now?
Your lordship, I was not in this matter in the earlier case, so I'm not aware of this case. Miss Livika was appearing in this matter, lordship. Lordship, I'm not aware of this case. This
Anyway,
matter was.
then we do one thing, we'll issue a short notice. Get your instructions on, we're having it on 2nd. We'll state the office memorandum dated 27th. Because the question is, madam, if you are appearing on the next date, my question is this. There was a disciplinary proceedings. In the disciplinary proceedings, the petitioner was terminated. There was an apparent fault in the disciplinary proceedings because an inquiry officer was appointed even before the written statement was submitted.
Exactly.
So there was an infraction to Rule 9(2). So when this matter came up before me, so I instructed, what do you want to do? And taking into account that he was on leave, na? What was the ground on which he was terminated?
Yes, he was on leave, Miss Livika.
No.
Which?
This person was, why he was terminated earlier?
He was terminated because of not submitting the written statement.
No. He slapped somebody, na?
He just made a slap.
So making a slap to some of the officials, another person of his rank. So they had terminated him. Then because of that, I said that nothing doing, this is on a proportionality. Then the government came up and say that, look here, we are ready to reinstate without back wages.
Exactly.
She therefore said that, okay, we are not going to take back wages provided you reinstate. And it is under such circumstances this court passed an order. Now, after that, can you initiate the disciplinary proceedings on the aspect of the same?
Exactly.
This is the issue, okay? Luckily, I remember. Yes.
Now, just then, that 5 days that was provided to me is expiring on Monday, lordship.
That is why I'm staying the memorandum, na?
Lordship.
When I'm staying the memorandum, obviously you cannot file.
Lordship.
And therefore, I'm taking up before I leave on 2nd
Yes,
and finish it up. when Miss Livika comes.
Thanks, Lord.
Issue notice making it returnable on 2/9/2025. Miss A. I mean, the Learned Council accepts notice on behalf of the respondent numbers 1 to 5. Extra copies of the writ petition be served upon her during the course of the day. The petitioner herein is aggrieved by the action taken by the respondent authorities in issuance of a memorandum dated 27/8/2025, whereby, in respect to an incident which attained finality before this court, with an assurance being given by the state respondents that they would be reinstating the petitioner without back wages, and the order being passed by this court on 5/8/2025. It is the case of the petitioner, therefore, that the respondents could not have again initiated the same process, as no leave or liberty was taken at the time of disposal of WPC number 235/2023. The Learned Council, appearing on behalf of the petitioner, further submits that it appears that the respondent authorities are acting with malice in law, taking into account that the said respondent authorities have granted a bare minimum 5 days for the petitioner to submit the reply. And it is under such circumstances, the Learned Council, appearing on behalf of the petitioner, submits that the action on the part of the respondent authorities are in issuance of the face memorandum dated 27/8/2025 are on the face of it, are on the illegal, unauthorized, as well as uncalled for, taking into account that the issue have already stood settled in WPC number 235/2023. This court, having heard the Learned Council, also heard Miss A.I.M.E., the Learned Council, appearing on behalf of the state respondents, who submits that she has no instructions in respect to the said matter. This court, upon hearing the Learned Councils for the petition for the parties, and also the submission made by the Learned Council appearing on behalf of the petitioner that there is a necessity for passing urgent interim directions, else the respondent authority may take steps which would not only go against the order passed by this court on 5/8/2025, passed in WPC number 235/2023, but the petitioner would again have to face the similar fate of termination, in as much as adequate opportunity has not been granted. Taking into account the above, this court is of the opinion that the petitioner has been able to make out a case for surpassing certain interim directions. Next, this court further finds it relevant to observe that if no order is passed, the entire writ petition would become infructuous. Considering the above, this court therefore stays the memorandum dated 27/8/2025 till the next date.
Obligation.
If you're the petitioner spread for what will be approval. Granted 15 November 2023, issued by the Territorial Development. Now, here the fix is that in the year 2010, petitioner's father had given a plot of, had donated a plot of land for the construction of real development office cum store at gift rates. Now, the owner after the land had been donated on the assurance that the department will provide good for employment opportunities. Now, the owner may kindly come to an actual view, that is a page 14, the owner. Yes, your lordship, here at page 14, in actual view, your lordship, here the block development officer or the block D3 had requested the deputy commissioner to issue the landowner certificate. Now, your lordship, based on that, the deputy commissioner had issued, that is at page 15A, that is the type of your lordship.
Yes.
Page 15A, lordship. Now, based on that, the deputy commissioner had directed the PTU to produce a written document or agreement signed with the department as well as the landowner. Now, my lord, may kindly come to page 16, annexure 3. An agreement has also been made, which in the agreement, it has been specifically stated that my lord may kindly come to para 3. I may be allowed to read the launch. In whereas the donor generously agreed to donate a plot of private land measuring in the degree of S20 southwest at this work which was roughly made and executed in the year 2010 on the pretext of extending service benefit to the donor. Now, my lord, passing on the agreement, the petitioner had been on being learned about that victim post had been arrested. The petitioner had also made a request letter by way of representation and submitting all the requested documents. However, my lord, from nowhere the state respondent had appointed the one person namely Tengdi Kisangdam lordship, which is at my annexure 6, that is at page 21A, my lord, that is the type copy lordship. So lordship being with the petitioner spring for washing into appoint on the basis of land ownership lordship.
What do they say? The affidavit filed by the respondent.
Lordship, in the affidavit filed by the state respondent, the state respondent has stated that the petitioner father had already availed the paid for, which they have annexed in the annexure. At annexure 3, that is at page 15. Now, my lord, the petitioner father was appointed in the year 1997. Now, my condition is that this matter pertains to the land which was donated in the year 2010. And then more specifically, even in the agreement, it has been mentioned that to avail a bid for which was donated in the year 2010.
Your lordship. First of all, since the whole foundation of the petitioner's case is based on this agreement which they are relying upon, which is in page 16. If we carefully peruse the agreement, this agreement, and before that, your lordship, the petitioner is alleging, purporting that they have donated the land twice. From what he said, they are really not talking about the old land, they are talking about the land which they have submitted, donated in 2010. But Lord, there's no such thing. There's just one plot of land which they have donated years back. And they have not donated the land in 2010, as they are alleging. The lordship, even the This,
Understood, but why the subdivisional officer,
yes,
first and foremost,
yes,
after the 2018 notification,
Yes.
if you read paragraph number 1 or 2,
yes, yes.
read it, paragraph 2.
The office memorandum. Even we are contesting this, with this agreement, which is signed by the BTO.
That is why I read paragraph 2.
Yes. 1B, Your Lordship. In case the department concerned is of the view that the agreement should not be declared null and void, it shall refer it with relevant details giving justification to the Department of Land Revenue for it.
No, prior to that, after, on the
yes.
top of it.
It has been laid down by notification dated such and such that no, notification dated 26/7/2005, that no land shall be acquired free of cost, and all land shall be acquired on payment of full compensation as determined by law.
So
No?
if that be so,
Yes,
how can there be a land donation in 2010?
yes. That is what we are contesting, Your Lordship. The land was donated prior.
But why did your subdivisional officer
Yes.
or your deputy commissioner do all these things?
That is, I have mentioned in my,
What action have you taken against these people?
I have no.
No, this is serious because
Yes.
because of this. First, if the petitioner has given the land in the year 2010,
Okay.
you could not have, because it has been already on the basis of a notification in 2005
Yes.
that there shall be no land taken on donation, the land will be acquired. It is only prior to 2005, 3A, 3B, 3C will come in, isn't it?
Yes, yes.
So therefore, first, secondly, the agreement which has been entered into is of the year 2023.
Yes,
How is it possible that there can be an agreement with the block development officer?
yes,
Isn't he acting contrary to the law?
yes.
Huh?
Yes.
What action have you taken?
That, with regards to the action taken, I have no instruction. Your Lordship.
You see,
But
there is a serious thing.
yes, yes. But with regards to that action.
Forget
yes,
about him.
Yes.
But I think we should take action against them. So we pass an order, take action against them. Against that block development officer. Whoever has done that, signed that document, as well as the subdivisional officer. Why he has issued the land ownership certificate? Tell me. We see his petition. Kindly see this. First, let us see the office memorandum. Kindly see. It has been laid down by notification number so and so that no land shall be acquired free of cost, and all land shall be acquired on payment of full compensation as determined by law. No further condition for the employment in service or contract should be entertained. Therefore, in case any department has entered into an agreement with the landowner in deviation of the land policy of so and so, such agreement shall be treated as null and void. The departments concerned shall take necessary action according to nullify such agreement. In case the department concerned is of the view the agreement should not be declared null and void, it shall refer it with the relevant details giving justification in the personal Department of Land Revenue for examination and advise in consultation with PNR and Justice and Law Department, and thereafter submit the matter for consideration and decision of the Cabinet. All cases, now we are concerned prior to that. All cases where administrative headquarters and block orders were set up in various parts of the states of land donated freely by villages of so and so should not be reopened for compensation or employment in consonance with the policy brought out in 1977. In other cases, prior to Iman and subsequent to setting up of Iman, so 3A, 3B, 3C only applies for those prior to 2005. Now the petitioner's case is of 2010.
That is what they're,
Isn't it the case of the petitioner is of 2010?
that is what they're saying, yes.
Then there is an agreement entered into by the block development officer in 2023.
Yes.
These are all illegal.
Yes.
That's your case.
Yes, Your Lordship.
Said, bad case.
My lord, in the meantime, my lord.
You may not have thought about this. You think about it. We'll have it some other day. Why should I dismiss your last case of the day? There's another case.
Yes.
Is anybody waiting for the other matter? That day, one case I said I had disposed it of. That matter has come, na? Because who is appearing for the other side? Because what has submitted during the course of the hearing was wrong. There were 5 petitioners, of which 2 petitioners even did not complete. So that file. This is a very serious thing, and I was supposed to pass an order. While passing that order, then these people gave it to me that this can't be done. One কাগজ খন ক'ত বনাইছিলে এখন তো বনাব দিছিল মই সত্য মোক মাতকচোন
Your Lordship, it's in my affidavit in opposition. Page 9.
No, not this. You see, you have proposed his name.
Yes, Your Lordship.
How do you propose his name? Because he has not completed 30 years.
Yes, Your Lordship. I'm sorry.
This is a
My
wrong
sister-
affidavit. You
Yes,
should,
Your Lordship.
it couldn't have gone there.
Yes, Your Lordship. I also just.
Because
noticed
that
this
day,
morning, Your Lordship.
while dictating the judgment, I asked them to look into that. You kindly see this document. This is how I prepared it. Then I saw, how is it possible? This is as per the affidavit. 1 or 2 petitioners can be done, but not the petitioner number 2 and 3. You see that details given. One has only 25 years. 25 years, he cannot get it, but it has been forwarded. Another person is 29 years. 29 years does not come within the benefit of this.
Yes, Your Lordship.
So how do you take care of it?
Yes, Your Lordship. I have seen these anomalies this morning, Your Lordship, and I have informed the department also.
This is wrong there, what they
Yes.
have done, madam.
So, Your Lordship, with regarding to the regularization, the other petitioners may be, orders may be passed with regard to other 2 petitioners, Your Lordship. As for these 2 petitioners, Your Lordship,
Where's the petitioner council?
Your Lordship is not available today.
We'll have it again next Monday or Tuesday. I read the file, I know it, but this is what has happened. But the problem which appears, there should not be clubbing all the petitioners together. It becomes very difficult for the court to pass. That day there were 2 petitioners made. Then the problem arises is from which date his regularization will happen. Because I pass an order by which he's entitled to regularization on the date on which he gets 30 years. It may take 6 months because the last clause of 17.3/2015 says that you have to take the concurrence of the finance, PNR and all these things. This may take more than 6 months or 1 year or whatever may be. But whenever you do it, give him the benefit from the date he gets it.
Yes, Your Lordship.
Because that is the law. So therefore, that becomes very difficult when there are 3 petitioners. Anyways, you keep a copy of this, and you ask him to pick another copy. We'll again have it. Taking into account the counsel for the petitioner is not present. However, Ms. A. Ahmed, the learned government advocate, is present. Taking into account the learned counsel for the petitioner is not present today. We're going to list this matter again on 2nd of September 2025. Ms. A. Ahmed appears on behalf of the respondents, state, and submits that there seems to be some discrepancy in the proposal to send the names of all the petitioners for regularization, in as much as some of the petitioners is not qualified in terms with the notification office memorandum dated 17.3/2015. Full stop. List this matter. Is it 17.3 or 17.9?
17.3.
17.3/2015. Accordingly, list this matter again on 2nd of September 2025.
Much obliged.
Yes, you have a bad case. Your entire case, your block development officer, he made the mess. In fact, if anything is done, if that agreement is to be recognized, that has to be also recognized only by cabinet. Without the cabinet recognition, this certificate is also non-est.
My lord, now, the condition of the private respondent is that, well, the appointment of respondent number 5, due process has already been followed. However, my lord, who is not the landowner who was appointed in this, private respondent number 4, due process has also not been followed, my lord, which is annexure D, page 13 of the.
So now you give up your land ownership basis.
No, no.
And now you stick to that when the respondent number 5 has been appointed not on land ownership basis, then the mandate of 14 and 16 has to be followed. Isn't it your submission?
Lordship, even that process has also not been followed.
That is what I'm saying. 14 and 16 has to be followed. So have they stated, how did you appoint the respondent number 5? Only on the basis of approval?
Yes, Your Lordship.
How? There has to be selection process.
Yes.
So there the petition against. But is it on affidavit there? Have you put that question in your petition?
My lord, in my main petition, I stated it para number 14, lordship.
Para number?
14, lordship.
You do one thing, Mr. Counsel, I won't dismiss your petition. You file an additional affidavit, bringing on that aspect. Okay? Then it would be regularizing your grounds, saying that in terms with that particular year, you may not be entitled to the benefit of the land ownership certificate, ownership. But however, if the respondent number 5 has not been appointed on land ownership basis, then the mandate of, there has to be a proper selection proceedings and put that. Once you put that, then I will take it up, let the state file their affidavit what they have. Okay. And let the private respondent's lawyer, as well as the private respondent, enjoy the benefit of getting his salaries for the time.
It's already.
You were also not appointed as per following the due process.
The appointment is on state state.
There are many judgments I passed, they also passed the judgment. You look into that judgment and the last 3 paragraphs of that judgment, put it on the affidavit. Don't quote that, but bring that. Okay. The learned counsel appearing on behalf of the petitioner submits that taking into account the notification dated 16/8/2018, the petitioner at best may not be entitled to a claim in terms with the land ownership basis. But however, the petitioner was one of the applicants, and as such, the respondent authorities, while selecting the respondent number 5, ought to have carried out the selection proceedings so that the best available candidate could have been appointed. The learned counsel submits that the same aspect was not done, and as such, it is a case where there is a violation to Article 14 and 16. The learned counsel, however, submits that he would like to file an additional affidavit in that regard. List the matter when?
After 1 week.
List the matter on 11th September. You see that judgment of mine, incorporate those and what I have stated, bring it. And then on 11th of September 2025, the affidavit be filed by 10th of September 2025.
Lordship, interim may be continued.
Interim is going on?
Yes.
Oh, interim is going on, then on this basis only I set aside this approval. Why should I go into He's not enjoying it. So we said, aside, go ahead with the proper selection proceedings.
Okay, Lord.
Why do you need it?
Okay.
As per your discretion.
Yeah, full stop. Submitted, full stop. The learned counsel appearing on behalf of the respondent state, hey, additional affidavit in the learned counsel for appearing on behalf of the respondent state that he would obtain instruction as to whether there was any selection proceedings. Taking into account the above, list this matter again on 3rd of September 2025. After the rising 3rd of September 2025, full stop. The interim order passed earlier shall continue till then. So then on that day I'll finish it off. Let him give a chance. After that, it will take the 15 minutes. I've passed so many orders on land ownership. You see that judgment, in that this you know any appeal court is there? What is his name? Recently, you typed out, huh? I think 3 days back, 2 days back, I passed one order. Give it to him. Him, take it from him.